point again, about when a child comes of age. That's all I'm saying. So I'm saying, if we are still talking at a conceptual level, let us at least accept that the two concepts are not mutually exclusive. That's really the only simple point I'm making. Now, if we move from that, it doesn't mean there are no situations where it's only a change of status and other situations where it's only a change of personality. The only point I'm making is that the two are not mutually exclusive. One. Now, let's come to the second point. The second point is this. Let's leave the conceptual now and come to the point of this case. The confusion which often arises in these cases, particularly to do with the public protector, arises from the following. The term the public protector, and that was the original appellant, if you like, has got two legal meanings. And when we say the public protector is the applicant or appellant, it automatically encompasses two legal concepts, right? The one is the institution called the public protector. The other is the person, the human being, called the public protector. So this is one of those cases which accord with the example I just gave, where a person, if you like, not graduates, transits from the one status to the other, right? Now that confusion is fairly common, but it can be easily explained. If you go to Section 181 of the Constitution, it lists the institutions that, like the Public Protector, the Auditor General, and so on and so on, so-called Chapter 9 institutions. Right. If you go to Section 182 of the Constitution, it then tells you what are the powers and functions of that institution that has just been referred to in Section 181. So that's the public protector qua institution. But if you move on and go to Section 193 of the Constitution, you will find that it's now a different, same appellation now assumes a different meaning because it now attaches to a human being, right? So we must just be able to separate between the institution and the human being. So Section 193 of the Constitution says, how do we know that it's talking about a human being? It says that only in the instance of two of those Chapter 9 institutions, the Auditor General and the Public Protector. Those are the only institutions where what I've just said applies. So if you talk about the others, ICASA and so on, the institution is the institution. So if you say the commission or whatever, you mean the collective, not the human being. But in the case of the Auditor General and the Public Protector, it says the President shall appoint a man or woman to be the Public Protector or the Auditor General. That means now we're now talking about a human being, man or woman, because an institution cannot be a man or woman. So that's the real conceptual confusion that occurs. Now, so which status has been lost? The status that has been lost is for Ms. Mkhwebane as the public protector in the Section 193 sense. So all that has simply happened is that, in this case, just because of the removal, it could have been by a fraction of time. The removal is irrelevant but for whatever reason, she has, while the matter was proceeding, has stopped to occupy the office. And by the way, quite separately, if you go to Section 5 of the Public Protector Act, there's another person that is envisaged. That person is called the Office of the Public Protector. It's not relevant for the present debate, but it also has become a source of unnecessary confusion. And the Office of the Public Protector is, in terms of Section 5 of the Public Protector Act, is a juristic person. So you have three entities, if you like. You have the Public Protector as an institution, Public Protector as a person, and the Office of the Public Protector as a juristic person. All those three can bring proceedings.
So what is the legal consequence of her
of her removal?
Of her removal, of
yes.
not occupying
no longer occupying the office, yes.
Protected.
Yes. It is this, Justice Nicole. It is that she, and that's why we have the Rule 15 notice. It is that she no longer can say, I'm here, let's forget the third, in those two capacities that I mentioned. She can no longer say, I'm here in this capacity.
Which capacity?
That is the representing the institution, the institution, the Section 181 of the Constitution capacity. She cannot do. So that's the first legal consequence, Justice Nicole.
And in which capacity had she litigated throughout?
Well, that's another interesting question. That question was debated in cases such as the Commissioner for SARS versus Public Protector, 2023, Volume 1. Can you just put it?
No, in this matter.
No.
I'm not talking about historically. In this matter, in which capacity had she litigated throughout?
In all the capacities.
So I mean, just when you say all the capacities, what do you
okay, let me say both, so that I leave the other.
And what are those two? I mean, just let me make a note of exactly what it is. How do you define it?
Okay, let's go through it. Section 181 capacity, let's call it that for shorthand.
And what would that be?
That's the institution.
And if one is litigating in that capacity, how would such a litigant be described on court papers for the purposes of having standing?
Well, you would say, okay, both ways. If she was the applicant, she would say that I'm here as the public protector appointed in terms of Section 181, I suppose. That would be the simplest. In other words, what it would be saying is that, okay, let's say it was an action. It will make it much easier if it's an action. If it's an action, whoever is suing here would say the defendant is the public protector.
No, if she's suing someone, how would she describe it?
It's the same. Okay, let's assume she's suing someone. If she was the plaintiff, she would say the plaintiff is the public protector. That office is at such and such a place in Pretoria. Now, that would be in the one sense. In other words, if somebody damaged the property of the offices of the public protector, that's what the particulars of claim would read like. But if somebody stabbed her, right, then she would say, in the office, let's say, to make it easier, she would say, the plaintiff is either Busisiwe Mkhwebane or the public protector, and now she would be referring to the 193 capacity. So that's a very good question because it makes it clear.
Why would she do that? I mean, let's just use the analogy of judicial office, for example.
Yes.
If I'm involved in a motor vehicle collision and I sustain injuries,
right,
and prosecute a claim against the Road Accident Fund, for example,
yes,
I would be cited in my personal capacity. My occupation would be that of a judge.
No.
But as the plaintiff in that matter, I would be cited in my personal capacity because those are personal injuries that I've sustained.
Yes. No. That's That's why I put that rider to say, to make it easier to say, if that motor accident happened in your office, inside your office, I don't know how that would happen, in the parking lot. Yeah. Then I'm saying you could say yourself, let's say you are now suing the Department of Justice because the accident happened just outside here. You'd say the plaintiff is XYZ, a judge or judge president or whatever the capacity of that person of the High Court. But what I'm trying to explain is that when you do that, that's a completely different thing to if you were going to institute an institutional proceeding for the SCA as such. Okay? So the plaintiff...
And the nature of the proceedings that we are dealing with here,
right.
I mean, are these institutional proceedings? Is it intended in any way to vindicate rights or obligations that inhere to the office of the public protector?
It's both. That's exactly the point. There are, for example, some of the claims before you are based on Section 10 of the Constitution, human dignity. Another claim is based on Section 34 of the Constitution, the right of everyone to institute proceedings. Those claims are clearly attached to her as a person. So you can't unscramble the egg. The point is that it's your example.
Let's just test that. How would
yes.
that compare, for example, to a situation, is there any comparison, to a situation where, for example, the public protector has issued a report which is now being challenged?
Yeah, absolutely.
And in those circumstances, I mean, one would imagine that there's a clear dividing line.
Absolutely.
In other words, it would then fall to the office of the public protector
absolutely.
to seek to protect the integrity of that office and to protect the work of the office.
No.
Now, is there an analogy between that and this?
No. Okay, you're making two mistakes.
Am I?
Yes. The first one is the
Most people would say I usually make a lot more than just two mistakes.
No, today is only two. You have a discount. So the first mistake you're making is that, and that's what I was trying to avoid by making this explanation. Once you utter the words, the office of the public protector, you are in another world altogether.
Oh, really?
Yes.
Okay.
Which is Section 5 of the Public Protector Act, which is nothing to do with what we are about here today. So that's wrong. So let's come back to the two that are relevant for today. I was trying to avoid exactly that mistake because many people make that mistake.
Sorry, but before you get
sorry,
in her papers,
yes.
She describes who she is and how she comes to
Yes.
court.
She does.
And it has nothing to do with any one of the two sections, 181 and 192.
It does.
How so? Because she gives a description and she is appointed in terms of section
1 big A.
Protectors Act.
Yes.
She stops there.
No.
She stops there. What else is she saying? When you look at her notes, at her filing affidavit.
Can I answer now? Right. When she says in her particulars of, in her founding affidavit, that she is appointed in terms of Section 1 big A of the Public Protector Act, what is she saying? She's saying that I am not here in the Section 181 capacity. Justice Ponen has made a very good example. In other words, I'm not here as I would be here if someone was saying, we don't like your report. Because the report is not hers as a person. The report is for the institution, right? How do we know that? We know that by going to, sorry, I don't know what I did. Yeah. We know that by going to to what the founding affidavit is telling you to do, which is go to Section 1 big A of the Public Protector Act. And you will see there a miracle.
See a what?
A miracle. Because this division that I made of 181 and 193 is actually verbalized in black and white in that section. So you can't read this and know what she means without actually, after reading this, going to the Public Protector Act, and then this is what it says. Section 181 big A2, which is the same thing as what I just said earlier. The President shall, whenever it becomes necessary, appoint a public protector, right? This is now a person, not an institution. The President doesn't appoint an institution. Appoint a public protector, and here's the part. In accordance with the provisions of Section 193 of the Constitution. Okay? So that it can never be clearer than that. That what we are dealing with here, if you actually read page 1 of the founding affidavit, the answer to this, what looks like a conundrum, is very easy. Because that section takes you directly. It doesn't take you to section. If she was suing about, as Justice Ponent correctly says, about a report, she would say, the public protector in terms of section 181, which is the question I answered earlier to Justice Ponent. So, I'm sorry.
I just need to get it clear in my head.
Yes.
So she's not here in her capacity as the head of a Chapter 9
No.
institution. She's here as what? In your...
Yes. All right. Okay. Let's take it slowly. So what has happened, if everything that I've just said here, if, let's say, the objection was, which it was, by the way, in the Western Cape High Court, because at that stage, she was still the public protector. And the so-called cross-appeal is based on that objection, if you remember. The cross-appeal says, no, she might be cited as a public protector, but she must be mulcted with personal costs because she's here as herself, because she's here to put it simplistically, to protect her labor rights. I'm simplifying.
Well, advancing a personal interest.
Yes, I'm just saying I'm simplifying a complex thing. That's what the entire so-called. So it's that's why these parties, at least.
Well, we'll get to them. But I mean, perhaps you can just deal with that question, because what's tending to happen is we are going down little rabbit holes, and let's try and avoid doing that. The question that was put to you, and I'm going to ask my colleague to repeat the question because I think it's an important one.
I know the question. I was simply, it was not because I didn't hear the question, I was simply giving context to my answer, but let me go straight to the question. So she is here in the same way that she was, she's in here in now two other capacities. Certainly she's not here as the public protector, because that office is gone. That is why, if that office had not gone, Justice Nichols, there would have been no need for us to file a Rule 15 application. Maybe that makes it clearer. The only reason that we have filed a Rule 15 application is exactly because she no longer occupies that office. Otherwise, we would have come here. And if one of my colleagues said, well, she must tell us, is she here in 181 or 193?
So is she here in her personal capacity?
Yes.
She's here in her personal capacity.
Has she been throughout before the court in her personal capacity?
Has she?
Throughout the litigation, has she been before the court in her...
If she was throughout the litigation, there would be no need for a Rule 15. You can't say, I'm here, have you always been an executrix, or have you always died?
What is the change of status then?
Yeah. That's exactly what you've just postulated, that she was previously here in her official, in a personal capacity, but as the public protector. All right? She's now here before you as Advocate Busisiwe Mkhwebane. Right? The mere fact that it goes to your example about the accident in the office, you would be suing the RAF as yourself, as a human being, like all of us. But if you are suing the Department of Justice for the whatever claim might lie against them, then you might be suing as a judge or any other official capacity. So, if you had those two capacities, and then you went to the court and they say, "Are you the one or the other?" You would say, "Well, I'm both." There would be no need to a Rule 15. The very thing that has necessitated Rule 15 is the fact that she hasn't died, thankfully. She hasn't been rehabilitated as an insolvent, thankfully. She has simply changed from being here in that 193 capacity to being here as herself. That's why there's a Rule 15 notice application. That's the whole point of that exercise.
Well, can we just, now that we've got to this point,
Right.
why is Rule 15 applicable in this instance?
Right. Okay. I've already answered that, but let me do it again. Firstly, Rule 15.1 talks about proceedings, and it says whenever.
Is it available to a litigant after judgment?
After judgment?
Yes.
In which court?
In the court below.
Yes.
Why do you say that?
Because, you see, that's the confusion with the case that you gave us in Chambers. Says that...
Are you aware of Kader versus Frank? That's a 1926 AD authority. The case of Kader versus Frank.
No.
That's a 1926 AD authority, a judgment by Innes CJ, who says the following.
Mm-hmm.
It does not follow, however, that after notice of appeal, they could have claimed to be substituted upon the record for the purposes of defending the appeal. Now, and consistent with that, the academic writers appear to suggest the following. Harms, for example, says it's doubtful whether the rules applies to a situation after the grant of judgment, and an application to court may be necessary where it is desired to substitute a party after judgment has been given. Erasmus puts it more strongly, saying, in view of the proviso, application to court will be necessary where it is desired to substitute a party after judgment is given.
Yes, but okay, that's another... the answer to that is also very simple.
And that is actually endorsed. That approach, the approach by Erasmus, is actually endorsed in the authority that I'd sent to, that I'd favored counsel with this morning in Chambers.
No, it is not. Let me explain. When you talk about proceedings in the context of Rule 15,
yes,
right? Here, you are talking about these proceedings. The confusion...
About the appeal.
Pardon? Yes,
We're
these
talking about the
proceedings.
appeal.
Yes.
Now, why do the uniform rules apply in this court?
Because this court has...
Doesn't the SCA have its own rules?
No, it does, but that's the Justice Ponan. You know, we're here about a court that, the previous court at least, took a technicality out of a very serious situation. So now...
Sorry, what is that supposed to mean?
No, I'm saying that well, what we're debating now, as I said, I'll start with the technical...
Well, it is technical, because substitution of parties is a technical matter.
Yes, that's what it means.
And it's got to be conceptually correct.
No, I know.
Yes.
But I thought you were questioning whether it's technical or not.
Yeah.
That's what I mean. Yeah. So I'm saying that the technical... In fact, this, with the greatest respect, is even worse than what the Western Cape Court did. Because what we're now saying is that we want to non-suit a person who has come to court simply because, imagine, if this were correct, you would non-suit someone whose constitutional rights have been violated because, why? If you ask, no, because Rule 15 doesn't apply to the Supreme Court of Appeal.
Well, if Rule 15 doesn't apply, you could have applied to court a proper application supported by affidavit, in which event, if the other side was going to suffer any prejudice, they could have opposed the application, raised the prejudice, and the court could have ruled on it.
Yes.
So it's not like she would have been entirely remediless.
No.
She would not have been without a remedy.
No, Justice Panan, your first question is the correct one, because, as you know, the entire purpose of Rule 15 was to do away with the necessity before in 1926 or whenever in a situation.
In appropriate circumstances, Mr. Mpofu, and I mean, if you look at, and that's been consistent with the authorities of this court. The first question you've got to ask is whether or not Rule 15 applies in a given situation.
Yes,
if it does, you invoke Rule 15 and you comply with it.
Yes.
But if Rule 15 doesn't apply, and look at how we got to this point. We got to this point because one of the respondents wrote to the current incumbent of the office, wrote to the Office of the Public Protector to say, are you aware that this appeal is being prosecuted ostensibly in your name? The response that elicited was, actually, it's not happening in our name.
Which is true.
Okay. Then, what they then did was, they raised questions as to the authority of the attorney to act. And in response to that, a Rule 15 notice was filed.
Okay.
Am I wrong? If you say no, am I wrong?
Half wrong.
Okay.
Obviously, you're right that that's what happened. But
I mean, I'm going by the correspondence, not anything that you may be saying from the bar, but I'm going by the documents that have been filed on record in this matter.
So am I, with respect.
Okay, so if you want to point me to something which indicates why I'm wrong, perhaps we can start there.
Okay. Can I start?
Would you want to point me to something which indicates why I'm half wrong?
No. Can I do it by a shortcut? I'll come to that, believe me. Can I just give you a shortcut? Rule 15, this court has applied Rule 15, right? And this court, when it applied, not in 1926, it might have been different because that time the Rule 15 did not exist. The reason Rule 15 was introduced was exactly to do away with what you are saying, Justice Bonan, which is the need to do an application, an affidavit, and so on. That's the reason why Rule 15 is there. And this court, in the judgment of Marais N.O. versus Maposa, in which one of the judges was Justice Nichols, fortunately. It's reported at 2020-5, SA 111, SCA. A judgment delivered by this court on the 25th of March 2020. This is what this court said, unanimously, per Plasket JA. Paragraph 5. Rule 15.1 of the Uniform Rules of Court provides that proceedings do not terminate solely because of the quote, death, marriage, or other change of status of a party, unless such proceedings is thereby extinguished. Rule 15.3, and then it goes on. And then at paragraph 11 let's start with paragraph 9. It says that, I would have expected the respondent, to have agreed to be substituted as an appellant without hesitation. And then here's paragraph 11, which is important. The court said, I am satisfied that Mr. Murray ought to be substituted as an appellant in terms of Rule 15. Okay? That passed, the last 3 words I added because of paragraph 5. Yeah. I also take the view that despite his unacceptable abdication of his duty as an executor, which was relevant to that case, Mr. Shongwe should be substituted as appellant too. The opposition, my learned friend's credit, there's no opposition here. The opposition to what?
Because there is no application to which there could be an opposition.
Well, but they're here. If there was an application, they wouldn't be here.
No, I say there is no application to which there could be an opposition. All you did was you filed a notice in terms of Rule 15. And that's what we're debating.
Okay. Let me read, I'll come back to the SCA case. Let me read what Erasmus says about this. The purpose of Rule 15 was not to afford the High Court the power to substitute a party to proceedings. It already had and still has that inherent power in terms of Section 173 of the Constitution. Under the common law, when the rule was introduced, the rule is designed to simplify the procedure where a party to proceedings has undergone a change in status. Previously, when a party died, married, or became insolvent, attained majority, was placed under curatorship, and so on, it was necessary to apply, right? So the rule is intended exactly to do away with the application you are talking about. Not at least so. According to Erasmus.
No, the authority of this court in Techmed.
In Techmed?
Techmed, yes.
Yeah.
Clearly indicates that there are instances where Rule 15 will not apply. And in that event, a substantive application is necessary.
No, of course.
Do you accept that?
No.
Okay.
I mean, that goes without saying.
Yeah.
That goes without... That's the whole point. The law used to be like this. In every instance, you had to apply for substitution, right? Then comes the introduction of Rule 15, which says in these instances, you don't have to apply. That's all I'm saying. I'm not saying every instance under the sun. Okay. That's not what Rule 15 did. It did away with the need to do an application in situations such as the one that we're dealing with, and such as the one that in Maposa was. Remember, your question was, does Rule 15 apply to this court? And I'm saying this court applied it as about 4 years ago, in 2020, unanimously. We'll come to TechMed just now. This court applied it in. I've now lost my place. I'm sorry. In Maposa, and I was when Justice Bonan came in, I was still reading this. It says.
Sorry, Mr. Mkhwebane, does Murray Maposa help you? Because there it was the substitution of an executive. So it was squarely within the ambit of Rule 15.
Okay. Can I please beg you, Justice Tipena, I'll come to that question just now. Can I finish? Because otherwise, I'm never going to finish reading this paragraph. It says, because this is also important and it covers what you say. The opposition, as I said, there's no opposition here, to what ought to have been a formality was unreasonable. In other words, the other side for opposing the Rule 15 application was criticized by the court. With the result that Ms. Maposa and Ms. Lidwaba must bear the cost of the application, while SIEP whatever. Anyway, so the point is the matter is that what the court was saying there is what I've been saying. To oppose an application or notice, which is a substitute for an application in these situations, where, as you correctly say, Justice Tipena, the matter fell squarely within the rule, was unreasonable, which is true. That's why this court said unanimously. But now let me come to your question. There is no difference, unless if we want to, we just want to nitpick and say, okay, this one it was an executor, this one it was an insolvent, this one it was...
That's a change of status. I mean, that's not nitpicking. That's, our law has always operated on that basis.
Okay, can I answer the question?
Your client has been around throughout. She's not suffered any recent disability, has she, which has resulted in a change of status?
Can I answer Justice Dipena's question, maybe?
Yeah.
Right. So, Justice Dipena, that this matter here, in our respectful submission, also falls squarely in Rule 15. And let me explain Rule 15.1. Let me explain how. When, as we all know as lawyers, when you have that catch-all, I can't remember the Latin phrase, but when you have that catch-all phrase at the end, I think it's called the eius dem generis rule. So what does Rule 15.1 say? It says, whenever arisen by death, tick, marriage, tick, and other change of status. Now, what we're saying is that the catch-all phrase, other change of status, means things that are not death, are not executrix, are not marriage, right? So, in other words, the writers of statutes or rules cannot or are not expected to list every conceivable instance. So the phrase "and other change of status" means that there's no distinction between the Maposa situation and this one. Thank you. Now let's come back to I'm sorry, just a second. All right.
Basically, your argument in a nutshell, if I understand it.
Right.
Correct me if I'm wrong.
Yes, just.
She's not the head of a Chapter 9
No,
institution.
she's not.
So she's now instituting, or she's now before us in a personal capacity.
Absolutely.
Like any other person in the
Yes.
street.
Advocate Busisiwe Mkhwebane.
Yes. Therefore, Rule 51 applies to her because she's had a change of state.
Yes.
And we must make of it what we will.
Absolutely.
But that's your case.
That's the case, and it's really based on the following. And Justice Nichols, I'm sorry to repeat myself, but the point of the matter is that had that change of status not occurred, there would have been no need for us to do a Rule 15.1, which is not opposed, by the way, by the other side. And to go back to Justice Ponan's postulation, you must look the mere purpose of Rule 15. You must look at that notice. In fact, don't even call it a notice; call it an application, because that's what Rule 15 sought to do away with the need for us. If there was no Rule 15, we would have had to put an affidavit and say, hereby, please, because I was removed on such and such a date, and so on and so on and so on, and the other side would have made a decision whether to oppose or not. But Rule 15 has been put there to ensure that we don't have to do that. It's the same as it is said in TechMed. TechMed is the case that Justice Ponan has said. At paragraph, I think it's paragraph 14 of TechMed. Yes. At paragraph 14 of TechMed, let me just give the citation. TechMed is TechMed Pty Limited versus and others versus NISHO, NISSHO, EY Corporation and so on. And it's 2011, bracket 1, SA 35, SCA. This is what is said at paragraph 15 of that judgment. As I see it, This focus should therefore immediately be directed at the substitution application, which is where we are now. The settled approach in matters of this kind follows the considerations in applications for amendments of pleadings. Broadly stated, it means that in the absence of any prejudice to the other side, these applications are usually granted. Now, that was a judgment of this court by Brandt J.A., sitting with Arams D.P. and Malan J.A. Right? What does that mean in simple English? What it means is that Rule 15 must be looked at a philosophical level in the same way as we look at Rule 28. Rule 28 was introduced to say, look, I can give you a notice of amendment. If you don't oppose it, then it's in, right? I will only be called upon to put an application if you oppose it. So that's the simple purpose of Rule 15. It was to do our, that's what Justice Brandt was trying to explain. That you, just as in the case of amendments, firstly, it's a facility, but secondly, it should be granted, quite frankly, unless if there's a serious opposition, which there isn't here. And we move on with the case. That's really what so this court has twice. Firstly, in Tekmet, it has said that, and then in Maposa, it has actually followed its own advice by applying Rule 15.
Can I ask you, I mean, how is one supposed to construe the proviso?
Pardon?
How is one supposed to construe the proviso?
The proviso in Rule 15.2.
In Rule 15?
2.
1.
Okay, well, I'm not aware.
Sorry, 15.2.
Yeah, I thought maybe I didn't know the rule. Yeah. No, the proviso is in Rule 15.2.
Yeah, in Rule 15.2.
Yes. No, okay. This is how you read the proviso in 15.2. You have to first understand what is meant by in 15.1 by proceedings, where it says any proceedings. Now, again, this is another common mistake.
Well, it says no such notice shall be given, and that's the notice that we are debating.
Yes, the application
shall be given. No, it's just the notice. It's not an application. It's just a notice. No such notice shall be given after the commencement of the hearing of any opposed matter. How are we to construe that?
Okay, simple again. Firstly, and again, I'm sorry, I'll answer. Firstly, this application is not opposed. But second,
well, I keep saying we're not talking about, we're confusing concepts, and it's important to get terminology right. This is not an application. All you did was you just served a notice in terms of Rule 15, which, if Rule 15 applies, would be perfectly permissible.
No, but it's the same.
So it's not the same.
It's an application, Justice Bonner.
No, with respect, it isn't.
It's the same as a Rule 28 amendment application.
With respect, it is not. All you've done is you've served a notice. Now, can we just debate the proviso? Because I think terminology is important.
Yeah, but
because what happens is if we get terminology wrong, that's where conceptual confusion starts to creep in.
Yes.
Now, how do you say this? And I pointed you to the 1936 judgment.
1926.
Yeah, the 1926 judgment earlier. But how do you say? How is that in any way inconsistent with what's contained in the proviso?
Okay. You see, the problem is that I can't explain the terminological problems if I can't speak.
Yeah.
I'm still saying, I'm in the middle of addressing your exact question.
Yes.
So if I'm allowed to speak,
of course you're allowed to
speak.
Yes,
okay, good. Now, the proviso in 15.2
yes.
applies, how it applies to these proceedings, Justice Ponan, is that we cannot bring the Rule 15.2, the Rule 15.1 notice before after the hearing, after this hearing, okay?
After which hearing? Sorry.
This one. Okay, so that's what I was explaining. The conceptual mistake is to think that rule, that 15.2 talks about the Western Cape. No. It talks about here. Okay? So,
No, well, let's just start with,
yes,
if there had been a change of status during the course of the hearing in the court below,
in Cape Town.
in the court below,
Yes,
if there had been a change of status before that court,
right.
at what stage of the proceedings would Rule 15 apply, and at what stage would it not apply?
Okay.
So at what stage before the High Court, now forget about on appeal,
Yeah.
at what stage before the High Court could one merely by notice in terms of Rule 15 signify a change of state, a substitution of parties?
Good. Now, to answer that question and try to kill two birds with one stone to save time, let's differentiate between Cape Town and Bloemfontein. So in Cape Town, to answer the question from a Cape Town point of view, the stage at which the notice would have been invoked would have been at the beginning, right? In other words, if we stood up there on day one, I think it was a 3-day hearing, and said, my ladies, and it was 3 lady judges, my ladies, we are bringing a 15-1, then the proviso would apply. Forget Cape Town, let's throw it away. Now come to Bloemfontein.
No, sorry. At what stage of that proceedings?
I've just said, as we stood up,
Yes.
right? Like that means literally at the beginning. Yeah.
Yes.
Okay, so that because of the proviso, that's when we would raise it. And then I'm saying, let's...
So at that stage, would it still have been permissible to merely just file a notice in terms of Rule 15?
Yes, if it was at the beginning, it was before the hearing.
Yeah, no, when I'm trying to get the dividing line, I mean, the proviso creates a clear demarcation in terms of process and procedural steps.
Okay.
And it's not as if one can just sort of pass over that, because it's an important differentiation.
No. It's okay. Okay, let me explain it. It's not, the proviso it doesn't bring any miraculous dividing line. It simply says that if it was in Cape Town, no such notice shall be given after the commencement of the hearing of any opposed matter. Okay?
Yes.
The commencement of the hearing means the day when we stand up and say, I appear for so and so and so and so.
Okay.
So after that point, you may not give a notice in terms of 15.1. That's all it says. That's really, it's that simple.
Okay.
So that's what it means, and that's the answer. That's why I thought I'm using it graphically to say that when we stand up, that's the point, okay? Here, forget about Cape Town now. Here in Bloemfontein, you also may not give the Rule 15 notice until the day of the hearing, which is today.
No, of any opposed.
Yes, the opposed proceedings here now is the appeal. So all the proviso says is that if we came here and did this appeal, and then sometime after the hearing we say to you, here's a Rule 15, then the proviso would hit us. But we did this, I don't know when, 6 months ago, whenever we did it. So the proviso has got absolutely nothing to do with the present situation. All right. Right. Now, so so if we could have done it yesterday, for all I care, and it would still be in, the proviso would not apply. Right? Right. So but there are, I don't want to waste more time on this, but the TechMed we've already discussed. Black Sash, which is another case, makes it even easy. Okay, I'm going to address something which, let me leave it, because I think it will just provoke unnecessary debate here. But the other way to look at this is as joinder. So you can also look at it from that way. You can look at it as an amendment. By the way, you can bring a substitution application by way of Rule 28, just to emphasize the point in TechMed. And if you go to Erasmus, I think my junior's Erasmus might be dated. So, but if you go to the discussion of Rule 28 in Erasmus, on this version, which I'm not prepared to vouch for, it's D1-339 of Erasmus. So I can just say or thereabouts if this is the 2020 iteration of Erasmus.
Yeah.
You'll see it tells you the situations. And one of the situations says on appeal, that's under M, then it explains what happens. And then under N it says substitution of parties. So that's a discussion of the substitution of parties under Rule 28 now, because it can also be done not only under Rule 15, but also under Rule 28. But that's just as an aside. Yeah. Yes. The point I'm really making is this. You can look at a substitution from the prism of Rule 15, you can look at it from a prism of Rule 28, or you can even look at it from the prism of Rule 10, which is the joiner. So notionally, you say you are now joining Advocate Mkhwebane as a party. In Black Sash, and I think it's paragraph 4 of Black Sash, and I'll deal with Black Sash when I deal with the so-called cross appeal. What it says is that in situations where you're going to want personal costs, which is why, by the way, and I must commend my learned friends for not opposing the substitution application, because they would be speaking with both sides of their mouth. They can't say, on the one hand, she must be mulcted with personal costs, on the other hand, they say she must not be here.
Well, I thought that would probably be an argument they will advance against you.
No, you're thinking wrong.
Yes, okay.
Because if they do that, then they're going to be self-contradicting, because they'll be saying to this court, mulct some person in the street with personal costs, but don't allow them in here. What is that? So, that's exactly why, as I say, to their credit, they did not oppose the 15-1 because they were hoping for a bigger price, that they will get the personal costs. But all that aside, the simple point is really this, that you have before you an unopposed Rule 15 notice which substitutes...
Did the notice make provision for opposition?
Pardon?
Did the Rule 15 notice make provision for opposition?
Well, I don't know, but all opposition, there's no application in court or notice that cannot be opposed. I've never heard of such a thing.
No, I say, did the notice make provision for opposition?
Oh, the note, I'm so sorry. I thought you were saying the rule. I'm sorry, Justice Pana. Well, a notice in Form 1 of the notices, you have two types of notices. A notice Form 2. Form 2 is where you say...
No, I'm saying, did this particular notice...
No, it's a Form 1. Form 1 notice.
Yeah, so I'm saying, did this particular notice make provision for opposition?
No, it didn't, because...
I'm not talking about generically, I'm talking about this particular notice.
No, but I'm explaining to you the reason why it did not do so. Because it's a Form 1, not a Form 2 notice. Okay. That's the only reason. But the mere fact that you give a Form 1 notice, a Rule 28-1 notice for amendment is also a Form 1 notice. But that doesn't mean a party may not oppose. All right? So so I can assure you, my learned friends did not oppose this because the notice doesn't give them an opportunity. They did not oppose it because they don't want to.
We listened to their submissions in due course.
Well, I don't know what submissions they're going to make because they did not oppose the matter.
Yes.
This application, at least. This application I'm arguing now is unopposed. Let's just get that one out of the way. So it's an unopposed application. In terms of Rule 15.1. So no one has anything to say.
Is there anything else you've got to say on Rule 15?
No.
15 before we move on to the next...
To the next hurdle, yes.
Okay.
No.
Well,
there's a lot, but there's no time. Yeah.
Let's talk about mootness then.
All right. Sorry. Let me just see if I'm not leaving any. I'm sorry, Justice. Okay. I'll deal with it in reply if necessary. Let's, for the sake of saving time, then come to the issue of mootness. As I said, mootness, firstly, this one definitely overlaps with the merits of this appeal. The first one is arguable if it overlaps, but this one certainly does. Why do I say so? Because, as I say, this appeal is about a finding of ripeness. Let's forget the Latin, in medias res and whatever. What that thing is called is ripeness or prematurity. That's simple what it is. And ripeness is a corollary of mootness. The Constitutional Court has said that many times. So the issue of mootness arises, therefore, in two incarnations. As at least as raised by the other side, it arises on the merits, quote unquote, of the appeal. So if the court allows me, I will deal with it in that fashion. May I?
Well, no, I think the primary argument that's been raised is that whatever the outcome of this appeal,
yes,
it won't have any practical effect or result as contemplated in the Act, the Superior Courts Act, because it's been overtaken by a series of events. There are a string of subsequent decisions that have not been challenged, and so those decisions stand. And therefore, even if we were to be with you on the merits of the appeal, and we were to overturn the decision of the court below, even on the limited aspect on which it was decided, because it's been overtaken by these series of events, there would be no practical effect or result, as I say.
Yes.
Yeah.
Now, I know what mootness is. I'm simply asking whether I can address it in the way that it has been raised, which is that the summary you've made, Justice Ponan, is raised as a, if you like, a defense to the merits.
Sorry, I don't follow that. I mean, this is
okay.
You know, because
fine.
Because unless one gets past this obstacle, so to speak, unless one overcomes this hurdle, well, then one is not into the substantive merits of the appeal.
All right. Okay, fine. Let's do it that way. We'll do the long way. So 16, if we do it that way, then we have to look at it from the point of view of of section 16(2)(a) of the Superior Courts Act. It really amounts to the same thing because the test is the same. It says that if the judgment doesn't have a practical effect, and Justice Ponan has correctly summarized what that means, then, of course, the appeal is moot. So that's the first leg. The leg that came from all the line of cases from Van Wyk, Langeberg, Magidiwana, and so on. So those two legs go something like this. If you find I'm saying this because in my respectful submission, this inquiry will end on leg 1. But if for some strange reason I'm wrong on leg 1, then you have to go to leg 2, which is that whether, assuming now that the appeal is moot, whether you should not nevertheless hear it in the interest of justice. And I want to emphasize this. My submission is that you're not even going to have to need leg number 2. Okay, so let's come to the practical effect. How can anyone say that somebody, Advocate Mkhwebane, says, I have suffered multiple violations of my constitutional rights at the hands of these respondents. As a result of that, I had to go through an illegal process. I can't find a polite way of putting it. I had to go through an illegal process.
Illegitimate, perhaps.
Illegal, I think, is better. An illegal process which violated my Audi rules, which violated Nemo Udex, which violated everything under the sun. Yes. No, yes. Under Audi, yes. My junior correctly highlights the real issue, which is the denial of legal representation. So she says to a court of law, I went, let's say, to the magistrate court in Randburg. I'm exaggerating for effect. And the magistrate locked the door and told my lawyers, you're not going to get in here. And she comes to a court of law to say, I want to vindicate the Constitution and my rights regarding that. And she can be told it has no practical effect. That is not our law. Our law is the exact opposite of that. And it is that if a citizen of this country, at the hands of a public institution at that, has his or her rights, human rights, fundamentally entrenched in Chapter 2 of the Constitution, limited, infringed, violated, breached, whichever word you like. That on its own has practical effect. What is the practical effect? The practical effect goes back to what was said in 1996 in the case of Forze, which Forze versus Minister of Police. By the way, is the first case I ever argued in front of the Constitutional Court. And in that court, it was the following principle was established by Justice Ackerman, but more by Justice Krechler. That what was meant in the old, interim constitution, it was called appropriate relief. But what was meant by that is that the vindication of the Constitution itself is actionable. Which, by the way, goes to the difference between a declarator in terms of Section 8 of PAJA, which we'll talk about later, a declarator in terms of Section 38 of the Constitution, and a declarator in terms of Section 172(1)A, which is what we're talking about here. So a declarator that is in terms of Section 172(1)A is in a class of its own, and it should never be confused with these things of mootness and the delay rule and all that kind of thing. The Gijima principle, which is what I was talking about, says a court of law should do exactly the opposite of what I'm being asked to explain now. It says that when a court is in a situation where the vindication of rights in terms of Section 172(1)A is at stake, that court, in the case of Gijima, it's actually, and that's why there's been transient academic criticism, but unfortunately it's the law. But it says the following, that even in a situation where you cannot explain the delay, the undue delay, the court must overlook that and vindicate the Constitution. Right? Now, that principle was debated at length, and one of the judgments, I just forget the name, I'll find it now. Justice Nichols was dissented with Justice Jafta in the Constitutional Court on the application of this principle. But the best articulation of the Gijima principle you will find in the case called ASLA, Buffalo City Municipality. ASLA Construction, yes. The court knows, if the court just allows me, just change. Before I go to ASLA, let me just say this, just to piggyback on what my Elena Jr. was whispering here. Remember that impeachment, part of this illegal process I was talking about, resulted in her impeachment. But whether it did or didn't, really, quite frankly, is irrelevant for the point that I'm going to make. Because even if she was acquitted at the Section 194 committee, she would still be here to vindicate her constitutional rights, which were, to say violated is an understatement.
But what order would she be seeking?
She would be seeking, you see, that's exactly the point. She would be seeking an order in terms of 172.1a. 172.1a has been said from a long line of cases, for Nkandla case, all these cases, that must not be mistaken with the declarator where you are dealing with mere private rights.
No. I mean, it's important for us, again, not to confuse concepts. Okay?
It is very important.
Because an appeal lies against substantive order of the court below.
Yes.
Not the reasoning.
Yes.
And much of your submissions are actually targeted in a more generalized sense against reasoning.
No, it's not.
Well, let's look at the order that was sought in the court below, and let's see how much of that would still have any practical effect.
Right. Okay, let's go. That will be volume 1. Yes, I've got it.
Right. So, these decisions in paragraph 2.
Right.
If those decisions were to issue now.
Sorry, just I'm listening, sorry, Justice. I just want to find my notes here. Yes.
In other words, if this court were to substitute the order of the court below with one granting any of this relief, why would that be an order that would have practical effect going into the future?
You are at paragraph 2.
Well, all of the relief that was sought in the court below.
No. All right. Okay. At paragraph 2, the declarators that are sought at paragraph 2 address what I've just explained here now in great detail. So she says, I want this court to declare that those decisions to dismiss the recusal application and so on, must be...
all these decisions that were taken in October 2022.
Yes, are unconstitutional and invalid, right? Now, that's a archetypal Section 172.1a. It might be other things, but what I'm saying now is that is a 172.1a order, such as was envisaged in Gijima and ASLA, right? So, a declarator of, this is the point. 172.1a does not deal with private rights, per se. It deals with the violation of the Constitution of the Republic of South Africa as a whole.
So you're saying that we should grant these orders in order to vindicate her constitutional rights to dignity and various things, irrespective of whether it would have any impact on her subsequent impeachment.
Yes.
Is that?
Yes. No, except for that last part. I'll explain why. I'm saying Justice Nichols, and that's why I was making it clear. And maybe your formulation is actually correct. When I say irrespective, I mean, that's why I was saying to Justice Ponan, assume she had been found not guilty in the Section 194 committee. That makes it much clearer. I'm saying, even if she was found not guilty, she has a right under Section 172(1)(a) to come here and say, my rights, the locking out of my legal representatives, in my exaggerated example, the fact that the panel that sat there included somebody who's married to the complainant. You can list, all those things. I don't have to go through all of them. There are like 17 of them. Those things amount, as she has pleaded, to the violation of my Section 10 rights and my Section 34 rights. How are the Section 34 rights implicated? Because Section 34 of the Constitution says that you have a right to present before a fair tribunal, forget a court now, before a court or tribunal. So those two rights at a minimum of mine have been vindicated. And you must, the Constitution says, you must hear that, make those declarations.
I understand that. But
yes.
Why are you saying that's not irrespective of the outcome? Because it's
No.
irrespective of the outcome. She said we must vindicate her rights.
Yes.
It doesn't matter what the...
That's exactly what that's all I'm trying to say.
Okay.
Thank you.
Got you.
That's all I'm trying to say. I'm saying you have a duty. It's not it's not may, as in 172(1)(b). You must.
We've got to vindicate.
You have
her
no
rights.
option in the
Yes,
matter.
I hear you. And it doesn't matter whether she's impeached, not impeached, whatever. I get
Yes.
your argument.
That's the Gijima principle. The Gijima principle says that in Mkhwebane CJ in the Nkandla case explained it, I think it's paragraph 113 or 103, where he says, sorry.
If you're going to be moving on to going to be moving on, I'm just looking at the clock.
Okay, can you just give me 1 minute? So
Yes, I was going to say I'll be guided by you, and when
Yes,
we
yes,
reach a convenient point
Yes.
in your address to us, just bear in mind that we would be taking the short adjournment
No, thank you very much.
at your convenience.
Thank you, Justice. I won't be long. I just want to break at a natural point here. No. Let me then, because this submission is key to this entire appeal, by the way. That's why I was saying, I was trying to say, you cannot apply the wrong test as the Kota did. Because if you miss, which, in fairness to that court, they frankly admitted it. If you look at the judgment of the application for leave to appeal, they say we simply did not address the issue of the declarators, in all fairness to them. But I'm saying you cannot do that because you are leaving out an entire cause of action which has a life of its own, unlike all the other pleaded alternatives. And if you allow me just to say this, because again this simplifies it, and it might be easier maybe to say this before we go to the break. This is the kind of thing that we teach to pupils. The reason why you plead in the alternative in the first place is so that if you lose cause of action A, then the court must go to cause of action B. Basics. Nobody can quibble with that. What this court did, which is unforgivable, was to say, you lose cause of action A, but we're not going to look at cause of action B. Who does that? Because that confuses the entire judicial function, which is to say, if you are wrong with your cause of action A, and for the purposes of this, I'm not abandoning it, assume we had to lose the review leg. Then the court was enjoined to then say, okay, let's now go to the cause of... This court failed to do that. That's what's wrong with it. Given that the egregious nature of those violations, in any event, this is not a case where you can say, I've already discussed that it has practical effect. But even if it didn't have practical effect, this is a case where, because of the 172(1)A nature, and that goes directly to your question, of the cause of action that was ignored in Cape Town, you are free to overlook, quote unquote. Now, I use the word overlook advisedly, because this is what I've been trying to say, the overlap between this issue of mootness and the entire appeal. I'm going to argue that you are entitled to overlook both mootness and ripeness, right? Which is what the appeal is about on the merits. But when I say that, I'll be saying that based on the very same principle called the Gijima principle. So the direct answer to your question is that this court does not have to go so far to say, if you have a 172(1)A, you may never be non-suited for mootness, delay, ripeness, the usual constitutional technical points that get taken. We're not requiring you to go that far. And there's no need in this case. And we are salvaged, as I say, by the egregious nature of the self-evident breaches.
So we can accept then, because there are a range of matters in the Constitutional Court where that court appears to embrace the jurisprudence of this court when it comes to the question of mootness. Yes,
including the one where you found in my favor, which was Makidiwana. If you remember, Justice Ponan, in that case, I was on the other side. And you raised this point and said to Mr. Marcus, who was my opponent, isn't this moot? Because in this case, the Marikana workers have already been paid. And we were out of here within an hour or so. Then the other side, legal aid, I think was my opponent, went to the Constitutional Court. You remember, that's the 2013 Magidiwana case. What that court said on a split of 10-1 was that it upheld your formulation. And that was because in that case, that court said these were so-called context-specific issues. And that's I'm in a way discussing the same principle, except Justice Nkabinde, who dissented, said you were wrong because the thing was not moot, it was still alive, and so on and so on. In fact, her judgment is much longer than the other one. It's a good judgment, but unfortunately, she was alone. Fortunately for me. Now, you've hit the nail on the head, Justice Panel, because the debate that is raging in academic circles about the Gijima principle is exactly what you're saying. Does this now mean that you can bring a 172(1)A application 20 years, let's exaggerate, undue delay, obvious undue delay, but simply because you are vindicating the Constitution, the court must give you relief? I don't know what the answer is, but my respectful submission is that this court doesn't have to go that far.
Okay. The second issue that I want to raise with you is this.
Mm-hmm.
Would we be issuing, if we are with you, would we be issuing, in effect, the sort of order that was sought in the court below, or would we be issuing some other order which, a la section 172, which would be sort of
just and equitable,
which would be declaratory orders that are not strictly confined by the relief that was originally sought.
Okay.
Because I mean, your debate has taken it, has moved it along a little, and I'm just wondering, what the logical flow of the debate would
understand. No, I was going to say on a lighter note, next time we won't allow you to go to tea, just this panel. Now, these questions are both difficult, but go to the heart of the matter. Actually, after answering that question, I should just sit down, because that really goes to the heart. What we are asking this court to do is, let's call it maybe threefold. The first is to say the obvious, that which I said before tea, that this court misdirected itself, to put it politely, in dealing with one cause of action and completely ignoring the other cause of action. Then comes the million-dollar question that you're asking. If you could do, no, it's not 3, it's 4 things. You could just do a declaration, 172(1)(a), which you must do.
What form would that take?
No, that's the simplest order. I can draft it now. It simply says that the following conduct, XYZ, whatever it is, the conduct of XYZ was inconsistent with the Constitution. That's a pure 172(1)(a) conduct. In other words, the fact that there was a denial of legal representation, the fact that there was a member who was conflicted and so on was in violation of the Constitution. Simple, everyone knows that. And so that's the first thing. The second thing you can do, of course, I almost said I'm dodging. I'm dodging the primary question. The primary question is whether you remit or deal with the matter, but that's a different question. Let's park that. The next question would be, as you correctly say, a 172(1)(b), because that's where you now have a discretion. You no longer have a gun pointed at you where you must declare. Now, 172(1)(b) says you may grant just and equitable relief, which we've asked for in one of the prayers that we were looking at. Now, and that's really the heart of your question. That in my respectful submission, we're going to say, in that rubric of 172(1)(b), first, let's look at what the Western Cape Court should have done. The Western Cape Court should have followed this court's binding precedent in 2 cases, Dyantyi and Dube. I call them the 2 Ds. In Dyantyi, and again, this is just my own shorthand because I'm not going to go through that long list of transgressions. So I'm picking one for shorthand. The logic is this: if this court is not prepared to find that the closing out of lawyers is a violation of the Constitution, then it will find nothing to be a violation of the Constitution. So I don't have to take you to all those other 15 things. If that is not sufficient for any lawyer, that a legal representation, which, by the way, has been granted by the Constitutional Court after litigation, as full legal, and then somebody decides, no, I'm going to deny you that. If that is not enough, then nothing ever will be. So that's the Dyantyi case. The Dube case then deals with the issue of Mr. Mileham. The Dyantyi case deals with the chairperson of the committee and the committee itself. The Dube case, you will, I'm sure will all remember, if I remind you, deals with the Mileham situation. Now, again, with Mileham, I'm not going to go into all those things about the tweets and what have you. I'll just pick one. And I say, if this court is not prepared to accept that it is a gross violation of human rights for somebody to be tried by a panel of judges of whatever, in which one of the judges, quote unquote, or decision makers, is married to the complainant. If the court finds that that's not a violation of the Constitution, it will never find anything to be a violation of the Constitution. So I don't have to go through. So that I'm going to confine it to those two most egregious violations. Now, what did the court do in Dyantyi? Which is what that court would have done if it hadn't mistakenly avoided the merits. In Dyantyi, the facts were almost exactly the same. In fact, our facts are better. And that is the case of, Minister, I'm so sorry. Dyantyi, not that Dyantyi was chairing the, Dyantyi, this one was a university student. Yeah. Dyantyi versus Rhodes University. 2023-1, SA 32. This was, in the Western Cape, this was what we call a lawyer's dream. Because this came out in January of 2023, and we argued the case in February. So it was hot off the press and unanswerable. But the court somehow managed to find a way around it. So this is what happened in Dyantyi. Almost the same facts. I can assure you because I was there. So Mr. Dyantyi is being represented in this, Miss Dyantyi, sorry, is represented by an advocate and an attorney, I think 2 counsel and an attorney in a DC.
That's the Rhodes University matter.
Yes, the Rhodes matter, yes. Then she is, the advocate is not available for some reason or another. And then the initiator, I think that's what that proctor, something like that, whatever that means. Yeah. But the person in charge then says, okay, well, I don't care that your advocate is not here. Your attorney is here. And is a lawyer. Let's get on with the show. Then she obviously takes that to court at the end of the case, and that's why the court mixed up the things. This court, of course, said in Dyantyi the proceedings were not in medias res, but that had nothing to do. We're not presenting this case for that. We're presenting this case for the merits, for the denial of legal representation. Anyway, this court said, per van der Merwe J.A., that you can't do that. You can't say your advocate is not here for good or bad reasons, and I'm just going to proceed, which is exactly what happened in the current case. It happened on the 13th of September. It happened on the 27th of October. It happened on the 1st of November. It happened on the 2nd of November. But even if it had happened for 5 minutes, in my respectful submission, it would be an egregious violation of human rights. So the court in Dyantyi said, you can't do that. You have to, and that comes to your question, Justice Panel, we're setting aside the finding which was made against Ms. Dyantyi, and we are, in that case, because it was what Cape Town should have done, we're remitting it back to Rhodes University, but they must have a different proctor, chairperson, whatever you call it. That is the typical order that is given. In Dube, the same order was given. In Gedezi, the same order was given. There's another case, I think in Cape Town, I forgot. But that's the long answer to your question. So what really should have happened is that those judges should have said, go back, minus Mr. Mileham, who is obviously conflicted, and the DA, if it wants, I suppose, could have substituted him and put somebody else. Why is that so? Oh, no, let me not jump to Dube before we finish with Dyantyi. So in Dyantyi, this court said, at paragraph 25, Ms. DeForce and Mr. Mkhwebane represented Ms. Dyantyi, I suppose those were the advocates, over the 12 days of the disciplinary hearing up to 11 October. The transcript of the proceedings up to then came to 700 pages. Let me pause there. That is, compared to, our transcript was at 60,000 pages. And then says, in such circumstances, the role of the instructing attorney is usually more of an administrative and logistical nature. There was no reason to believe that this was not the position in this matter. Thus, the ruling of keeping the advocates out deprived Ms. Dyantyi of the services of two counsel steeped in the matter. Exactly what happened here. Moreover, they did so at a crucial stage of the proceedings when Ms. Dyantyi was about to testify and to present the case. The suggestion of the university, or in this case of the government, that Ms. Dyantyi should have proceeded with only the assistance of Mr. Mdabe, in our case it was Mr. Sianego, and the candidate attorney was quite unreasonable in the circumstances. It would have been difficult to obtain the services of counsel willing to act pro bono and able to properly prepare within the 10 working days and so on and so on. This caused prejudice to Ms. Dyantyi that could only have been justified by powerful considerations. That was especially so because this could have been avoided by the simple expedient of setting down the matter on another date. Exactly the same here. Because
so what's your answer to the question is what order should we make here?
Well, I've just said the order that should have been made in the Western Cape.
Which is remittal.
Yes, which is, no. Remember, let's not mix two things. There's the remittal, which was done here, to roads, right? So that would be a remittal to the, Section 194 committee. You can't do that. It's gone, yeah. So there's another remittal with capital letter R, let's call it, so to distinguish it from the other remittal, which is called for now because you are this court has been placed in the unfortunate situation where the court in Cape Town has not dealt with the merits, which it should have on the principle of S versus Jordan, even if they found against us on ripeness. They should have decided the merits so that this court doesn't now have to be saddled with the merits. So that's another huge misdirection just on its own by that court. So you have now a burden to make a decision, if you are with me, whether to set aside or rather to declare, to give my declaration in 1721A simpliciter, or to remit the matter back to the Western Cape Court, which didn't do its job, to say it must do its job. With
what ultimately in mind for the Western Cape Court?
Yes.
Because I mean, assuming they were inclined to further remit,
yes,
as you say, there's no Section 194 committee.
Yeah. That remittal, Justice Panel, would have been in terms of Section 172(1)(b), all right? So I'm saying before you go there, you have to deal with the 172(1)(a), All right? So if you remit it to the Western Cape High Court, which failed to do what it should have done in terms of S. Jordan, all you'll be saying in simple English is that that court must not do what it says it did at paragraph 58 of its judgment, which is astounding. At paragraph 58 of its judgment, that court says with, don't know what to call it, frankness, maybe if you want to put a positive spin. It says, it is not necessary. It says, having found that, let's start at 57. Oh, sorry, you'll find that in the core bundle at page 20. Thank you. This is what that court did wrong, like, as I say. It says, we thus have found, had the application not been determined on the basis of the relief that had been sought in medias res, and accordingly that any review, underline the word review, so they were only deciding the review, not the declarative. Any review of the matter is premature, which for present purposes, let's say that was correct. Yeah. That any such review would be undertaken against the principle of legality and not under parja. True, we concede that. Well, we concede it for the purposes of today. I don't want later to be held to that concession if the matter goes to the Western Cape or to the... That concession expires at 5 today. So let's assume that we say it was not parja. Then that court then had a duty to then examine the review under legality. It failed to do so. That's a huge misdirection already. Then we go to 58, which is, this is the one that takes the cake. Then they say, it is also not necessary, given our finding that the applicant has sought relief in medias res, to determine, in other words, to decide. 1, the test for bias in proceedings before the committee established under Section 194, and whether a case for bias has been made out against either the chairperson or Mr. Mileham. How can that be? How on earth can that be? That because you have found against me on review on a particular cause of action, which, as I say, I concede for the purposes of argument, that therefore it now suddenly becomes not necessary for you to look into the next cause of action of legality and of whether there was indeed violations of my rights. And 3, they say, whether the issues complained by the applicant concerning inter alia, the widening of the scope of the inquiry, and the violation of her rights to audi alteram partem have merit. How on earth can it not be necessary to look into those causes of action? So that's it should offend the sensibilities of anybody who is seized with a matter of this kind. For a court.
Mr. Mpofu,
Yeah, Justice.
To that question you raised,
Yes.
not found in paragraph 47.
Yes, thank you. In fact, the big paragraphs in this whole judgment is 47, 57, and 58. Thank you. Let's go there, Justice Mkhwebane. So, you'll see a big note under next from me, next to 47, which says gist. So, yeah. So this is what they say in 47, which is completely out to lunch, with respect. So the applicant contends that gross irregularities. Remember, Justice Mkhwebane, they are now addressing the Walhouse test. Mm-hmm. So they are addressing. Remember, the Walhouse test says that in a review, please underline this: review, not a declarative. In a review, let's say from a magistrate's court, the court, the higher court, will only intervene if there's grave injustice or irreversible harm. I'm paraphrasing. That's what it says in reviews. Then there's another set of cases. Please forgive me, I'm also killing two birds with one stone. The other set of cases that they relied on relates to appeals. So that rule, the in medias res rule, applies to reviews and appeals. That's our submission, not to the alternative causes of action. The Sakau, Take and Save, and all those cases, Masangani, and so on, all the cases that this court relied on will either be dealing with an appeal or a review. So keep that in mind. Now let's hear what they say about the review. They said the applicants contend that gross irregularities have occurred in the course of the committee's work that are of such a nature that it is, quote, indisputable that grave injustice would result, which, as I say, I don't think anyone is going to argue otherwise, where the relief sought not to be granted. Yet she has pertinently not engaged in how her temporary lack of legal representation placed her at an irremediable disadvantage in circumstances when adjournment, in fact, eventuated after the medical certificate was considered. I'll show you that that's a complete, I don't even know what to call it. It's got nothing to do really with the case before you. Or how the alleged misrepresentations made by the chairperson and Mr. Mileham in the public domain grossly impeded her ability to continue presenting her case. That's again a sanitization of our real complaint about Mr. Mileham. It's got nothing to do with his so-called misrepresentations. The issue is, was he conflicted as a spouse or not? So they elide that as well. And then they say, in addition, considerations of time wasted and expense incurred do not warrant a different conclusion, including, I don't know what that means, including that we were informed by her counsel that the transcript was 60,000 pages. But that's a point in our favor. So, on the Dyantyi test. So, you're quite right. If this case was, let's assume, forget about the so-called alternatives. Let's say this case was purely a review. Then, if it was purely a review, there was no alternative cause of action that has been pleaded, then this finding would have simply been based on 47. But I'm in a good mood. So I'm saying, assume 47 is right. It's completely wrong, I can assure you. But assume it's right, and assume it's a good basis to dismiss the review. Then what? What then entitles a court to say, because of that, I'm not going to look at your alternative causes of action? What? There's nothing. There's no court in this country or any country that is entitled to do that. So, which is what they say at 57 and 58. Sorry, Justice Smith.
Yeah, so the question posed by my brother presiding, if you were to refer this bit,
right,
in your view,
if you're to remit,
yeah, to remit,
yes,
what would be the purpose of that? What do we expect the court to do?
Yes. I've answered the question. I would expect that court to vindicate the Constitution in terms of 172(1)(a), which it failed to do. That's the first thing I would expect them to do. Okay? The second thing I would expect them to, that one I wouldn't expect to do. They must do it. They have no choice. The Constitution says they have to do it. So it's not optional, whether I expect it or not. Then the second thing goes to 172(1)(b). Well, firstly, I'm sorry, Justice Smith, they would have to entertain the legality review, which they say is available themselves in paragraph 57. They failed to do that. Then they would have to give us a 172(1)(a) declarator of constitutional invalidity. And then thirdly, they would give, which comes back to Justice Ponan's question, they would have a discretion, which in my respectful submission they would have to exercise, to grant just and equitable, any just and equitable relief. Now, the question I'm asking just before you ask it to me, assuming that those other two orders are not controversial, what would be the nature of the just and equitable relief? Now, what we say is that they would have to say that, now because the events have, if it was still that time, they would have had to remit it, as I said earlier, to the committee without Mr. Mileham and maybe without Mr. Dyantyi. But now that cannot happen, or that's water under the bridge. What they can then do is to say that the proceedings up to the point of February or March, I can't remember, up to the point of February or March 2023, yes, which is when we approach the court on an urgent basis, that those proceedings up to that point were null and void. And that's what Dyantyi also said. Dyantyi said that I'm sorry. You'll find that at paragraph 33. It said the appeal is upheld, that's obvious order. Then it says the order of the court of call is set aside, that obviously also must happen, and replaced with the following. So that would now be the 172(1)(b) part. Quote, the decision of 10 October 2017 convicting the applicant of charges of kidnapping, insubordination and defamation is reviewed and set aside. How do you apply this here? The decision, remember what we've brought here, the decision of the Section 194 committee dismissing the recusal application, which was sometime in October, I can't remember the exact date, I think 17th October, if you look at the notice of motion. Sorry. I'm so sorry.
It is the 17th of October.
Yes. Decision taken on the 17th of October to do that is set aside. So that's number, if you use the Dyantyi order. Okay? Then go to B. Then Dyantyi says the decision of 1727 sanctioning the applicant by permanently excluding her from the first respondent is set aside. Okay, that may or may not be relevant. The matter, this is the important part, the matter is remitted to the first respondent for reconsideration on condition that any continuation of the disciplinary inquiry against the applicant shall take place before another proctor. In other words, not the biased one. That's obvious. Yeah. And then the first respondent is directed to pay the applicant's costs, including the cost of to counsel. Mind you, that in Dyantyi, that's why I'm saying our facts are better. In Dyantyi, the real complaint was just Audi, the denial of the legal representation. In our case, we complain about all the rules of national justice, Audi and bias. So obviously it would have to be a different...
In that matter, though, remittal was possible.
No. With a small letter R, the remittal to the university.
That's what I'm talking about.
Yes, not the remittal we're discussing
Okay,
now.
well, let's just go to your notice of motion. Page 2.
Yes.
Let's just look at paragraph 4.
Sorry. That should be volume 1. Yes. Paragraph?
Paragraph 4 of your notice of motion.
Right, yes. I'm sorry. Yes, I got it.
Yeah. Would any of that still remain as live issues?
Would it remain what?
As live issues. In other words, can that be...
No. Oh, I'm sorry. No, absolutely not. No, that's what I should have said as I stood up. Yeah. No, the so-called substitution relief is gone.
Okay, so paragraph 4 is gone.
Yeah, no, absolutely.
So essentially, your complaint is that the High Court did not, in circumstances where it should have, entered into some of the other relief that had been sought.
Yes. Let's start at paragraph 2.
And that would primarily be
2.
Insofar as paragraph 2 is concerned.
Yes. 2, and then paragraph 3, and then jump 4, scratch 4, and then paragraph 5, which is what we're discussing now. Paragraph 5 is the 172(1)(b) relief that we've been discussing. So 2, 3, and 5, and 6 obviously costs and would remain.
If what's contained in paragraph 4 is academic,
right,
and we accept that,
overtaken by events,
why is it that what's contained in paragraph 2 is not academic?
Because those two are two different animals. Relief under 172(1)(a) and relief under 172(1)(b), which is what substitution is, are completely different juridical animals, right? The substitution or remittal or whatever is the usual. Any review that comes before any court is susceptible to either a remittal or a substitution.
Yeah, but hold on. I mean, if in effect what's going to happen is merely an order setting aside these decisions, the recusal decision,
yes,
the adjournment decision,
yes,
and
the witness decision.
The witness decision.
I think we called it,
yeah, the witness decision.
Yeah.
Okay, so if in fact
you nullify those,
what the effect of the order would be is to set aside those decisions.
Yes, and nullify them.
Yeah, I mean, where does it take anybody?
It takes, well, anyone, if anyone includes Advocate Busisiwe Mkhwebane, who is before you, it takes her very, very, very far. And here's how. If indeed, and I don't know if okay, let me do it. If any human being is impeached.
No. I've heard some of the submissions relating to that, but I'm tying it up.
Yes.
I'm tying this question up to what's contained in paragraph 4.
Yes.
In other words, what one's going to have is a declarator in the air, so to speak.
No, there's no such thing. That's the point. That's what Krefler says. There's no such thing as a declarator in a vacuum. Okay. It does not exist.
No, that's fine.
In Fose, it says exactly that. That's why we have something called the Gijima principle, because it's against that notion that a declarator in the air might be possible in terms of Section 19 of the Superior Courts Act. It might even be possible under Section 38 of the Constitution, but never under Section 172(1)(a).
Okay, so we are going to be sending this back to the High Court so they can set aside those decisions.
Yes.
Decisions that were taken when? In 2000?
Let's say 100 years ago. Okay. But the point, Gijima says exactly that. Even if the decisions were taken 1,000 years ago.
No, that's fine. I think I followed the submission.
Yes, yeah.
Okay.
That's the point. You know, that really is the point.
So once the High Court, say they agree to do and they settle.
Right.
Then what? What is the effect of the order that
Okay. Firstly, that's just the wrong question, because you don't, when you are vindicating rights of human beings, there's no then what. So if you chop my hand and I say, okay, well, I'll never get it back, then what? It doesn't work like that. The mere vindication of the rights is the then what. Okay? So that's what Fose and all those cases leading up to Gijima says. That is a standalone generic. That's why it says the court must. The court. If it said the court may, we would be having this debate, because the court would be saying, well, but we can't have this debate because you don't have a choice in the matter. The constitutional drafters decided.
I think you've made that submission.
Yes.
I think
you follow.
I think we followed the submission.
Thank you. Yes.
Sorry. I mean, is there anything else you want to say in relation to any further submissions that you want to make?
Yes. No.
Yeah.
I just want
anything
to,
new?
No. This is what I want to do, Justice Panan. I am, thanks to the court and the interaction, I've actually covered the appeal grounds in all its three incarnations.
I think you have, yeah.
Yes. And I just want, if you just allow me just to knit the case together. And the way to knit the case together is to read only one decision, ASLA. Now, it answers some of the interactions that we've had. It says at paragraph 63, ASLA. I mean, this might sound a bit, but that's what the law says. The fourth principle, I think this was Justice Peron, stems directly from Gijima. And I'm going to read this part slowly. This is about the 1,000 years thing. It says, even where there is no basis for a court to overlook an unreasonable delay or moodness or ripeness or 1,000 years delay, even when there's no basis whatsoever, the party just comes here and says, I don't know why I delayed. The court may nevertheless be constitutionally compelled, right, to declare the state's conduct unlawful. So that's the 172(1)(a). This is so because, quote, Sections 172(1)(a) of the Constitution enjoins a court to declare invalid any law or conduct that it finds to be inconsistent with the Constitution. Full stop. So that's the law which Justice Teron and even the dissenting judgment of Cameron J.A. and yes, even that dissenting judgment did not upset the Gijima principle. And then I'm jumping to 66. She says, when would Gijima apply? Gijima dictates that where the unlawfulness of the impugned decision is clear and not disputed, I've made the Dyantyi Dube, then this court must declare it as unlawful. So that answers part of Justice Motle's question. This is notwithstanding an unreasonable delay in bringing the application for review, for which there is no basis for overlooking. Whether an impugned decision is so clearly and indisputably unlawful will depend on the circumstances of each case. We've gone through that. I'm not going to traverse that again. And so on and so on. There are many other. You can go to paragraph 68, 71, and so on. I'm not going to read them to try and save time. But please allow me. So the principle is crystal clear. But just allow me, please, to not to flog a dead horse, so to speak, to just say one or two words about the Dube case, just to emphasize the point. Assuming my learned friends are going to argue, which I would be surprised. Well, I wouldn't be surprised because that's what they do in their heads. What Dube says, I was just saying, Justice Mkhwebane, when he was still the judge president in the Northwest, sat in a matter, S versus Dube, where his wife was the prosecutor, the state advocate, right? Now, what happened is that Justice, the facts are quite strange, by the way. So the advocate knew that, he said he knew that Justice Mkhwebane had set in another appeal and actually found against his wife. So he says he didn't mind. But the appellant looks at the judgment and says to the lawyer, why is the surname of the judge the same as the state advocate? And the advocate says, because they're married. But it's not a problem because I trust him, whatever he said. And the accused said, no, forget that. I'm having none of it. The decision must be set aside. And it was taken to here, to this court. Mhlanhla J.A. in this court dealt with the matter. Sorry. It's reported as 2009-2 SACR 99 SCA. You also find it in 2009-3 All South Africa at 223. To his eternal credit, Justice Mkhwebane said the following in the special entry. He said, impartiality is the fundamental quality required of a judge and the core attribute to the judiciary. It must exist both as a matter of fact and as a matter of reasonable perception. If partiality is reasonably perceived, that perception is likely to leave sense of unease, grievance, or injustice having been done, thereby destroying the confidence in the judicial system. The perception of impartiality is measured by the standard of a reasonable observer. The perception that a judge is not impartial may arise in a number of ways. For instance, by a perceived conflict of interest, by the judge's behavior on the bench, or the judge's out-of-court association. A judge must therefore avoid all activity that suggests that the judge may be. I'm reading from the paragraph 10, which comes from the Bangalore Principles. Sorry, the passage I was looking for is paragraph 17, where Mkhwebane says, we do so because we believe that perception by a lay person that a husband and wife may, in the secrecy of their bedroom, inadvertently or deliberately, find themselves talking about the case in which they are involved cannot be said to be frivolous or ridiculous, which is the case. An application for the recusal of a presiding officer in the position of the presiding judge, he was talking about himself, in this matter cannot be said to be absurd or an abuse of process, and an average right-thinking person would, in all likelihood, sympathize with the person in the position of the applicants in this matter. Needless to say, I've already read the other part from the Bangalore Principle. Needless to say, this court found that the grounds for the recusal of Justice Mkhwebane in that case were sustained. And the order that was given just was that in the result, the appeal succeeds. Justice Mkhwebane, the order of the court is set aside and replaced with the following. It says, the appeal is remitted to the High Court for a rehearing before a differently constituted full bench. Now, read what that order is pregnant with, which answers this. What it was saying was that because justice, here you wouldn't say it may or may not be a differently constituted bench. Because in this case, we're not complaining about any bias on the part of the three judges who sat in the Western Cape High Court. If we were, then we would be asking for an order like this. So it would be a matter that's left to the JP to decide if it's remitted. So I just wanted to please bring, it's a 2 or 3 page judgment, but if you take these 2 cases, Dyantyi, deal with the committee and the chairperson. Dube, deal with the Mileham recusal. In those circumstances, I don't know if I should preempt the so-called cross appeal. Let me do that in one sentence.
No, you can deal with it.
Yes, just for the sake of completion. Yes.
You can deal with it when you're on your feet later.
Yeah.
I mean, perhaps you may benefit from the debate that will be had with counsel for the other side.
Okay, I will not, because there's no they want personal cause against a person. So she's a person now. So the cause will be personal anyway. So, but anyway, I will maybe benefit from whatever they have to say. Sorry, this man. Those are our submissions.
Yes, thank you.
The appeal should succeed, and the order along the lines we've discussed ought to be granted. As the court pleases.
Justices, Justice Bond. I'm going to attempt to confine myself, unless the court wishes me to do otherwise, to the two preliminary points that are contained in your directions.
Thank you. I would, speaking for myself, I would appreciate that.
If I need to go beyond that, I will indicate where and why, Justices. And so it's my firm intention not to deal with what I call the merits.
Yes.
If we are called upon, as part of our address, to deal with the merits, my learned friend to my left, Mr. Naidu, will deal with in medias res and with the grounds of review to the extent the court wishes to hear them.
Yes, thank you.
So with that said, I'm going to deal with the two preliminary points. Now, my first submission, Justices, with regard to Rule 15, is that as a general proposition, it would find no application in this court. It is not designed with respect, and it doesn't state that it is applicable in proceedings before this court. So that's my first proposition. The second proposition is that in at least two cases that we've come across, and we looked at that obviously once we got your notes, so it's not in our heads of argument, Justices, but there are two cases which do deal with this question, and where this court has in fact invoked Rule 15 of the High Court rules. The first case is Ardendorf's Boerdery versus Shabalala, and the neutral citation is 2017 ZASCA 37. The judgment of this court on 29 March 2017. And in that case, Justices, if I could just read from para 18, there was the respondents in that matter applied for postponement of the appeal, and one of the grounds was that the second respondent had passed away and an executor had not been appointed in his stead to proceed with the matter. And this is quoting from para 18 of the judgment. Counsel for the respondent argued that time was needed to adjust the papers and to substitute the prospective executor. During argument, it became clear to counsel that non-substitution of the executor could still be done at a later stage. And then there's a reference to Rule 15, Justices. So there the court appears to accept that Rule 15 can be invoked at this stage. But I must point out, and can I just preface these remarks by saying, it would make my job easier, our job easier, and it would be convenient for us to say, yes, of course, they can invoke Rule 15 and have them before the court because we want costs against them. I can't do that properly because I must obviously bring these authorities to your attention, so I bring them to your attention. That, and our position is Rule 15 cannot be invoked at this point. And quite apart from that, they haven't properly invoked it. But I'll elaborate on that. So I'm just dealing with the jurisprudential basis. So this case says yes, but it provides no reasoning for that conclusion. So that's the one case. The second case, Justices, that we came across is in Gwenya.
Can I just ask, who was that judgment written by?
Who was the judgment written by, Justice? It was written by the bench. It was written by Matopo, and the bench was Shongwe, Majid, Van der Merwe, and Mbata AJ. And then the second judgment, Justices, is Gwenya NO v. Kruger, and the neutral citation is 2017 ZASCA 102. It's the same year, judgment handed down on 6 September 2017. Similar, there was an overlap on the bench. It was Shongwe AP, Bosiello and Majid, JJAs, and then Moho, Loa, and Furi, JJAs. And in that matter, Justices, Mkhwebane versus Kruger. And in that case, Justices, the judgment in para 1 says that Council were at the outset required to address whether the appeal in any order mode would, within the meaning of section 16.2a1 of the Superior Courts Act, have any practical effect or result. And after hearing argument on the issue, the appeal was dismissed for costs. And it would indicate the reasons would follow. These are the reasons. That's para 1. And then in para 4 it says the following. On 27 January 2017, before the hearing of the appeal, the first respondent passed away. This resulted in the parties being requested on 21 June 2017 to file supplementary heads of argument on the preliminary question referred to in paragraph 1 above. In other words, the question that I've just read to you about section 16. The parties duly filed supplementary heads of argument, and I should add that at the commencement of the hearing of the appeal in this court, Justices, an application was granted pursuant to Uniform Rule 1512, in terms of which, basically, the respondent who died was substituted for the first respondent in this appeal. And then the court goes on to deal. So again, no reasoning and no jurisprudential basis laid. So those two judgments are against us on the issue, but we say they have no reasoning with great respect to them. Then there is the judgment that you handed to us this morning, Justice Ponnen. And as we read the Cilliers judgment in para 25, which you brought to our attention, there the court too appears to accept, but on my reading of this judgment, again without any reasoning as to how it arrives at that conclusion, that Rule 15 can be invoked at this point, and then takes the point of the fact that it had not been invoked, and raises the question of the proviso, which you've made, or which you've raised, and says that leave of the court was not sought. My learned friend responds to that by saying, well, you can do that at any time before the hearing, but the logical, or we submit, the jump of illogic that he makes is to read the rule as if it's applying to the SCA. It obviously applies, Justice, to the court, I quote, the High Court. You cannot once, and that's what the rule says on its face, it doesn't speak of the SCA, it doesn't speak of an appeal. So we submit that his answer doesn't address the issue of whether you can invoke the rule at all in this court. We say you can't.
I think in part that's probably the reason why, for example, Harms and Erasmus expressed doubt as to whether or not Rule 15 can apply post-judgment, and that's post-judgment in the court below.
Yes. Now, all of those, Justices, are interesting questions, but as we all know, my learned friend is quite correct about this. Rule 15 was inserted in the rules to provide an easy mechanism, because before that, as you quite correctly pointed out, we at least ad idem on that. I think it's possibly the only aspect this morning or today we are going to be ad idem on. The ad idem, Justice, is that before Rule 15, you required a substantive application to substitute a party. Rule 15 provided a shortcut, but it provided a shortcut under very specific circumstances, and the circumstances were a change in status. Now that is the elementary point, because with respect, if, as you put, my learned friend, if they brought a substantive application, Justice, in this court, or before, and in fact, as we will argue, it should have been brought before, because the facts are, there's a timeline that's very important to appreciate, and it goes back to the High Court, but also in this court, or what happened in this court, how the appeal was brought here. And we submit, to once again give you a shortcut to where we're going, we have, in terms, pleaded in our answering affidavit, and there was no reply to it. They never disputed this. We've pleaded in our answering affidavit, para 38, that upon the suspension of Advocate Mkhwebane, and I'm going to say Advocate Mkhwebane to distinguish her from the public protector, upon her suspension on 9 June 2022 by the President, she lost, by operation of law, Justices, Section 2, capital A, sub 7, divested of all the powers of public protector and those passed to a deputy in terms of that section. So that's an important date, because 9 June 2022 is when she ceased to have the power to act qua PP, public protector. And she never regained that power because although that decision was overturned by a full bench of the High Court in Cape Town in August of 2022, there was an appeal by both Parliament and the DA, and that suspended that order. There was a Section 18 application by Advocate Mkhwebane, which failed before the High Court. And those matters all went directly to the Constitutional Court. And that ended up as DA versus Public Protector, the judgment that we've cited. And I'll get to the relevance of that in the order, but the fact of the matter is, what's important to note, Justices, in the factual timeline, is that from 9 June 2022, Advocate Mkhwebane could no longer act qua PP. But yet, she instituted proceedings in the High Court under that guise as PP. And she noted the appeal to this court as PP when she no longer was such. To come back to the Rule 15 notice, the Rule 15 notice, Justices, as you, Justice Ponnen, have pointed out, was elicited by the Rule 5 notice by the DA in this matter. And in that notice, she was called upon to demonstrate by power of attorney that this appeal was properly before this court. And the response is the Rule 50 notice that attempts to supplant her for the Public Protector in her own name and in her own name. And she accepts, you've heard that this morning, that she does not litigate as the Public Protector. Now, given that factual scenario, we submit that had she wanted to effectively bring herself before this court as herself, Advocate Mkhwebane, she should have brought an application. That would have had the effect that we could have responded to it, and that the question of any prejudice, the question of the legal implications of the previous litigation, the attempt to come to this court would have been dealt with factually, and the court could have made a ruling in that regard. That is not what you have at the moment. You simply have a notice. And the notice, with respect, doesn't achieve the object of putting her before this court as in a personal capacity. Because, for the reasons I've given, well, those are the more technical reasons. To get to the substantive reason as to why the notice is not effective, Justices, there has not been a change in status such as contemplated in 15.1. The change of status, examples are given, we accept they're not exhaustive, but a change of status involves precisely that. And here there's not been a change of status in the office of the Public Protector. The Public Protector remains the Public Protector. The difference that occurred back in June is that she was divested of her powers to act as such, and then what happened subsequently, as you know, Justices, we've dealt with in our heads. It's also been found in the DA's Rule 5 notice, is she was firstly impeached by the National Assembly. That occurred in September 2023, and then she was removed by the President in that same month. Those are the changes that occurred. But that is not a change in status, or not a change in status in relation to the Public Protector. And the Public Protector is the party before you in this appeal. And we fully accept that this court has inherent jurisdiction to regulate its own process. This court could, we would submit, if you wanted to be conceptually clear, even suo motu, we would suggest, admit Advocate Mkhwebane as a party in this appeal. But that is not the application you have before you.
Well, even that
There's no such suggestion.
Even that may be technically a little difficult because, unlike the High Court, for example, our position is somewhat different. A necessary jurisdictional prerequisite is the grant of leave to this court. Now, if leave is granted to one party, and then you have another party standing up with a view to prosecuting that appeal, and that party is not properly before you, well, then there isn't a proper prosecution of the appeal. And we can't, by dint of regulating our own procedure, appropriate to ourselves a jurisdiction we don't have. It's only if we have jurisdiction that we can regulate our own procedure. So there's a preliminary step, in a sense, that's missing technically. If you follow what I'm putting to you.
Absolutely. What I'm saying is, there's perhaps I didn't express.
Unless the substitution in some or other guise succeeds, we don't have an appellant before us.
That is so. Because, with respect, that is abundantly clear from the Rule 5 notice. And Annexure B there too, which you have before you, we've been told. We inquired whether these documents had been placed before the court, and we were told it had. So you have a Rule 5 notice, albeit from the Democratic Alliance. It had two documents attached, one a letter from the attorney and then the response from the public protector. And that response is very clear. The public protector says, we did not authorize these attorneys to prosecute this appeal, to note an appeal or prosecute.
Yeah, well, leave was granted in my name, but I have no intention of prosecuting the appeal.
I'm sorry, Justice.
I'll say, essentially, the current incumbent of that office seems to say, leave was granted in my name, but I have no intention of prosecuting that appeal.
Not only have I no intention of prosecuting the appeal, I never authorized the noting of the appeal.
Exactly.
So, under those circumstances, Justices, with respect, the appropriate order that we say should follow, and those are the facts, which is why I wanted to make it clear what the facts are. The facts are suspension in June 2022, impeachment and removal by the President in September 2023. And notwithstanding those facts, supposedly the public protector continues to proceed with this case. But we now know, unequivocally, Justices, that the Office of the Public Protector never ever authorized that. And the question that you then ask, and as you quite correctly point out, that's the principal, very first question, before you go to any other legal debate, is there a matter properly before you? And we say that the crisp answer to that is no. There is no proper appeal before you, because it has not been authorized. And the relevant or the correct approach we submit under those circumstances is what occurred, Justices.
Well, there may not even be an attorney properly before us.
I'm sorry?
I say there may not even be an attorney properly before us. Because
there is no attorney in relation to the appeal, no.
Because the question that was raised is, are you duly authorized to prosecute this appeal on behalf of the person who got leave?
That's
and
correct.
The response was the Rule 15 application. So that
is an unequivocal.
The earlier notice, that wasn't regularized in any way either.
No, it's the appeal notice has never been, there's been no attempt to regularize that. The response to the Rule 5 notice, which expressly asked for a rule for a power of attorney, as the rules provide for, the rules of this court provide at any point the authority of the party can be requested to be established. That was expressly invoked, and the response to that was expressly not to provide such a power of attorney, which would then demonstrate that the leave to appeal, or rather the notice of appeal, had been properly lodged and the appeal properly prosecuted. The response, in fact, unequivocally was to accept that that could not be done, that proof could not be provided, hence the reliance upon, or the fallback onto Rule 15, which doesn't achieve any of the objects sought to be addressed in the Rule 5 notice. Under those circumstances, the only legal but also the factual conclusion the court can reach with respect is that there is no appeal before you. And that should be, well, must be the end of the matter. This court, as you quite correctly point out, Justice, has no jurisdiction to entertain a matter that's not before it. Notionally, the court could substitute a party, but that would be under, and the submission earlier mustn't be misunderstood to say the court will entertain a party before it who isn't before it at all. The court may resolve an issue sua motu within its inherent jurisdiction in relation to an appeal that it is seized with, non-constat that it will deal with the matter which it's not seized with. And we submit it's not seized with this appeal. Now, under those circumstances, the question is what does the court do under those circumstances? We submit with respect, Justices, and the principle is, and we say this judgment, the judgment of this court is analogous on the facts. It's the case of Land and Agricultural Bank of South Africa. Can I just check one thing, Justice? Land and Agricultural Bank of South Africa v. Parker and others, 2005, Volume 2, page 77, SCA. That was a judgment, Justices of Mpati DP, with Cameron, Brunt, JA, and Erasmus and Jafta AJA as the bench. And in that case, there had been a judgment of the Court of a single judge, which had then gone before a full bench down below. And the full bench overturned. The judgment of the Court of First, or the single judge, was a sequestration order. The court, the full bench, overturned that, and then it came on appeal to this court. And it became common cause, Justices, in the course of the matter, that the trust, who was the respondent in the Supreme Court of Appeal, had not been properly constituted at the institution and at the time that the matter came before the full bench in the appeal, because one of the trustees, the trust deed required 3 and there were only 2. There had been 3 initially, but during the appeal stage there were only 2. That was remedied by the time it came to this court. And under those circumstances, the court deals with the matter at para 45 and 46. And well, let me just read it to you very briefly. Before us, counsel for the trust sought to suggest that the original resolution of the three trustees adopted to resist the sequestration application covered subsequent steps, but this is manifestly not so. The resolution was only to oppose the application for sequestration in the High Court of South Africa. This neither contemplates nor authorizes an appeal, nor was the full court appeal at any stage ratified on behalf of the trust. Whether by design or oversight, no such ratification was attempted after the third trustee was eventually appointed. And then, 46. It follows that the full court should have concluded that the trust was not before it and struck the appeal from its well on that ground. The appeal must therefore succeed and the judgment of Ruja reinstated, and then it makes an order, Justice, in this court, upholding the appeal with costs, and the substitution order is the appeal is struck from the roll with costs, and then, importantly for our cross appeal, or not for our cross appeal, importantly for our argument before this court as to what should happen to the costs in this court, is para B of that order. The trustees, individually, the 2, who brought the appeal proceedings without authority, are to pay the costs from their own pockets, jointly and severally. Now, we submit that is the appropriate order for today, Justices. The appeal should be struck from the roll or dismissed. In the Celiers matter, the appeal was actually dismissed. So the court should dismiss or strike the appeal from the roll with costs. Given that there's a clear lack of authority, well, the PP is not here at all, hence it must be struck. The person who acted qua PP, who represented that she could prosecute this appeal for the PP, as in Parker, should bear the costs. And we would ask for such an order in respect of the so-called appeal, the proceedings before you. Those are our submissions on Rule 15, Justices, and what should happen to the matter today. I don't know whether the court wishes to hear me on mootness.
Well, even on the approach that you've just postulated, might I suggest that mootness may still not be entirely irrelevant, and it would perhaps be relevant in a slightly more nuanced way, and that's the following. I mean, assuming one gets past all of the difficulties that you've just alluded to, that's from the perspective of the party who now purports to prosecute the appeal. There's a line of authority, as with, for example, amendments and so forth to pleadings. There's a line of authority that appears to suggest where, for example, there is nothing meaningful to be achieved in ordering a substitution, then substitution shouldn't be granted. So, for example, even if there had been a proper formal application, not a notice in terms of Rule 15.
Sorry, you're talking about substitution of a party, not substitution as a remedy.
No, I'm talking about substitution of the appellant.
Of a party.
Yeah.
Yes. Yes.
So, what I'm suggesting is the following. I mean, in a situation where, for example, there is, had there been a proper application, in other words, had Rule 15 not been invoked, and had there been a proper application, and this court was required to consider that application,
Yes.
that's the exercise of a discretionary power by and large.
Yes.
But in the exercise of its discretion, this court may well have said, well, even if one overcomes all of these obstacles in the path of the appellant, there's still the question of mootness. So that in and of itself, at the tail end of the inquiry, will also render a substitution meaningless in the circumstances. I mean, I think that's what I'm putting to you.
Oh, I
so,
see.
yeah.
So do you want me to briefly address
No, I'm just raising it at that level. I know we've got your submissions on your heads of argument. I don't think it's necessary for you to, unless there's anything you want to touch on.
We will submit, Justice Ponnen, that clearly the court would be able to take into account the fact that if it had reached a firm view on mootness, that it would factor that into its consideration in the exercise of a discretion which we submit would be a wide discretion.
Yes.
It could consider that and would consider that, absolutely.
Yeah, I mean, what I'm suggesting to you is you'd find a line of authority, for
Yes.
example, where prescription looms large.
Yes.
And the court would say, well, there's little point in ordering a substitution because one way or the other, prescription would probably operate even as against the new party who's coming into the thing. And
Yes.
I'm saying, analogously,
In the same way an amendment...
yeah, analogously, if the matter is moot,
Yes.
then similar considerations should obtain.
Absolutely, absolutely. There is one aspect on mootness that we do want to emphasize, on mootness that we do want to emphasize, Justices, and that is my learned friend attempts in his address to you to draw a bright line between the 172.1a relief, he says, and the review relief, and possibly the 172.1b relief. With respect, as we read the notice of motion, that's not how this application was ever conceptualized and conceived. And just very briefly, the starting point is, even at the point where they noted the appeal, when they got leave to appeal, it's in the core bundle, Justices, at page... Their notice of appeal is to be found in the core bundle at pages 49 to 51. And this is the relief at page 50 that they sought to prosecute in this appeal. And you'll find in that, let me read it to you, it's para 2. This is the order that they want, that they came to court, that we've come to this court to oppose. It's 1, the appeal is upheld. 2, the order of the court a quo, which is the dismissal, is substituted with the following order. The application is granted, in other words, this is what the High Court should be doing. The application is granted as prayed with costs, including costs. The application is granted as prayed. No distinction, not alive, Justices, to the distinction between para 2, characterized as a different type of relief. They wanted all the relief as prayed. And if you don't have to strain yourself and do any injustice to the appellant / applicant, to Advocate Mkhwebane, by just looking at her notice of motion. Because on a plain reading of the notice of motion, Justice, the declaratory was always the springboard for the other relief. It's not pleaded. And I spent some time looking at the filing affidavit. And whatever the argument may have been in the court below, this is not the way the matter was pleaded. So if you look at the notice of motion, the declaratory in 2, declaring that these things were unconstitutional and invalid, flows naturally into 3, setting aside the said decisions referred to in 2 above, and then 4, substituting the said decisions. There's no distinction in 2 between 2 different types of 2 as a standalone declarative in terms of 172.1a, and 2 as a precursor to the consequential relief. You don't find that there. But what you do find is then 4, which again clearly is an order meant to be executory pursuant to 2 and 3. This is what they want. And that's and then the main, and you get that in 4.4, which is the next submission. This entire exercise was not, whatever you may have heard this morning or today, this was certainly never conceptualized and never moved. And you can also look at the urgency with which this was brought. If you look at the first page of the notice of motion, it was launched in November, instituted on 8 November to be heard 13, 14 December. So the whole thing was intended, and it says as much in the filing affidavit. It was, and you can see that most clearly from 4.4, because what they wanted, justices in the High Court, was an order in 4.4 that the committee proceedings will only take place after its composition has been duly corrected and or confirmed by this court. So the whole idea, this entire application was brought about, not to stop because they sought no interdict, but to get an effective order apropos those proceedings. That is how this was conceptualized. And the filing affidavit, with respect, makes that clear. Yes. Yes. So that was what this was about, whatever legal arguments you may have heard. For the rest, justices, we've dealt with the authorities, and just from the legal point of view, I just want to emphasize what we've said apropos Glenister 1. You find it para 59 of our heads. And Glenister 1 puts paid, we submit with respect to this notion that mootness and a matter not being ripe, which my learned friend says are flip sides, don't have application when one is seeking a 172.1a order. It does. And that's what Glenister says. Makes it very clear. And there's no conceptual basis as to why it shouldn't, with respect. So those are our submissions. I'm not going to take the court into mootness further.
Yes, thank you.
With regard to the cross appeal, just briefly, justices, we've made our submissions in that regard.
Why do you have a right of appeal? That order doesn't operate against your client.
I'm sorry?
I say, why would your client have a right of appeal? The order doesn't operate against your client.
A right of cross appeal?
Yes.
The order doesn't operate against my client.
As against your client?
As in my client being the chairperson of the Section 194 committee.
Yeah. I'm saying that relates to cost. That's an order that doesn't operate as against your client.
The order doesn't operate against our client.
I know you sort of acting in the public good and that kind of stuff, but so what? Why would that give you a right of appeal?
Justice, it's more discreet and focused than acting in the public good, acting for the public good. We as
No, well, you would have a right of appeal as against an order that operates against you.
There's no doubt.
In this instance,
well,
I know what the thinking was. You were seeking to ensure that the public purse is protected and that, in fact, the individual who was litigating for her personal benefit, that she would be held liable for costs. But ultimately, you came away from the matter with your costs. And in those circumstances, it's not like insofar as a cost order was concerned, you were out of pocket. You got costs. You may have got it from, not quite from the party that you wanted it from, but you got your costs. And so, to the extent that there may be any outstanding issues, that would be between the present public protector and one would imagine her predecessor.
Justice, the Constitution obviously requires Parliament. The public protector is accountable to Parliament.
Yes.
And it's in the exercise of that overarching power to oversee the activities of the public protector that we came to court on the cross appeal. So it's not some general desire to look after the public purse. It's located squarely within the provisions of the Constitution. It's section as it is section just as...
Well, can we then start with your answering affidavit?
Yes.
Let's just look at the two that I have in mind. I mean, the one is at 1518, and I think this may not quite be your client, but...
15?
This relates to the DA, and that is that they asked for the application to be dismissed with costs, and that's at 1518 and at 1569. So...
Of the record?
Yeah.
Oh,
and
sorry.
so, insofar as a cross appeal in their hands is concerned, I suppose they are probably in somewhat of a worse position than your client is. But the point still remains. I mean, ordinarily one would appeal against orders of court that operate against one.
Justice, this is not an afterthought. We always, so in our answering affidavit at para 343, page 775.
Sorry, just let me find that.
And this is not a surprise. It shouldn't be a surprise to Advocate Mkhwebane. I can also just point out that she sought a personal cost order against the chairperson.
Yeah, no, that may be so.
And in response, but I'll point that out. But 343, we say that should the application fail at 775, costs should follow the result. In such event, however, the long-suffering taxpayer will again have to pay Mkhwebane's legal costs, given the circumstances in which this application has been brought and the unmeritorious grounds. The court may well wish to order that she pay those costs personally. And then we ask expressly for such an order at para 424.2 at page 797. So she was put on notice.
No, that may be so, but I'm dealing with a slightly different point, and that is, at the end of the day, the application is dismissed. It's dismissed with costs.
With costs.
And so, it's not like any portion of that order operates as against your client, which would lend itself to an appeal at the instance of your client.
Justice, I can only say that Justice Bonnen, we asked for leave, we got leave, but I'm not going to press it. You have our submissions.
Yeah.
The cost in this...
well, that's a different kettle of fish in pie.
They differ, Toto Keller. I've made my submissions in that regard.
Yes, certainly.
And could I just point out, just my final point, is that in DA versus the public protector, the court made precisely such an order where it found in the Constitutional Court made precisely such an order. You have the case, it's referred to in our heads of argument, Justice, but I don't think this paragraph. 161, as to this cost of the Section 18 application for leave to appeal, the DA and the President sought costs against her personally. It is highly regrettable that this court and the other parties were burdened with an entirely unnecessary application. There is no indication that it was authorised by the Office of the Public Protector. In that case, there is no basis to hold the Office of the Public Protector liable for the costs. She must therefore pay the cost of the application in a personal capacity. So that's the basis.
Yeah, I understand the thinking, but I just have a bit of a conceptual difficulty with why an appeal would avail a party. Yeah.
Sorry. This is not made.
Okay.
Sorry. That was not in support of The High Court costs.
Okay.
In support of
Yeah.
the costs in this court,
Yeah.
today's costs.
Okay. You know, I mean, the one thing that struck me about this is, for example, the question of standing arose squarely before the judgment on the application for leave. And I know that judges on the High Court are under immense pressure and the workload is unbelievable. But that is almost just glossed over. It's passed over because that may well have impacted on whether or not, on mootness, on standing, on right to prosecute an appeal, and whether or not leave should have been granted.
Absolutely. I just want to check. Could I just check? I just wanted to confirm that was certainly argued by us just
Yes.
down below. That those were grounds not to grant leave to.
Yeah. Okay. Thank you.
As a good business. You do not then want to hear us on anything else.
Thank you.
As a good business.
Brief, especially with the application of Rule 15, before touching briefly on just two principles on the issue of mootness.
Yes.
The uniform rules, in relation to the Rule 15 question posed by the court, the uniform rules of court apply to the conduct of proceedings in the divisions of the High Court. The granting of the leave to appeal by the High Court and the noting of an appeal in this court, I submit, engage the appeal procedure which is regulated by this court's rules. There is no equivalent to Rule 15 in this court, which is a procedural mechanism. It doesn't establish a right, a power to substitute. This court would rely on its inherent jurisdiction for the substitution power. But as pointed out, this court has nevertheless utilized the mechanism of the Rule 15 in a few cases. Before turning to those examples and why I think they're distinguishable, I just want to reiterate 2 points in relation to the application of Rule 15. The first is the ability to utilize the mechanism requires it to be a situation as contemplated in the rule. And that's been confirmed by this court in TechMed, where it says the effectiveness for Rule 15 notice will obviously depend on whether it was given in a situation covered by Rule 15.1. The second point is there's also proviso to the application of the rule, which is set out in Rule 15.2, that no such notice will be given after the commencement of the hearing of an opposed matter unless leave of the court is given. Now, I want to turn to the instances where this court has utilized Rule 15 and explain why we submit that it's distinguishable. In Mkhwebane versus Kruger, the citation that's already been given to the court, at paragraph 4, it states that the court was dealing there with an application that was granted pursuant to Rule 15.2. In Murray and another versus Maposa, which was referred to on behalf of Advocate Mkhwebane, at paragraph 6, that was dealing with a situation where the executor brought an application in terms of Rule 15 for substitution. Paragraphs 10 and 11 of the judgment refers to that application being opposed. And TechMed again says at paragraph 13, where substantive application for substitution has in fact been brought, any investigation into the effectiveness of a preceding Rule 15 notice is most likely going to be a futile exercise because we now have a substantive application before the court. So given that there was an opposed application in that instance, the court need not have considered whether Rule 15 notice was the correct procedure to be invoked in the appeal court. In Ardendorf versus Shabalala, also referred to earlier, at paragraph 18, the court was dealing with the hearing of an appeal where the respondents launched a two-pronged application for postponement of the matter. One of the reasons being that the second respondent had passed away and an executor had not been appointed in his stead to proceed with the matter. During argument, it became clear that counsel thought that it became clear to counsel that the non-substitution of the executor could still be done at a later stage. But that was distinguishable, again, from the present instance, because there we were dealing with the circumstances where Rule 15.3 applies, which deals specifically with the substitution of an executor. Where it says,
but at their instance, whether it be an executor or a trustee or a curator,
correct.
So they seek to become parties, and it's at their instance,
Indeed.
not at the instance of someone else who may be already before court.
Indeed, Justice Brennan. And so the proviso in 15.2 that says you can't have it apply without leave in opposed hearings, that's not applicable to 15.3. 15.2 refers specifically to where notice is given for a circumstance that's triggered by the 15.1 change of status issues. And the last case we have is the silliest case that was provided us this morning, which again says where we have an opposed hearing, leave of the court is required. So for all those reasons, I submit the Rule 15 procedure in terms of just delivering a notice indicating there's been a change of status was not open to Advocate Mkhwebane in this court. But even if this court is not with us on this submission and says the mechanism for Rule 15 applies, she has not met the requirements set out in Rule 15.1, which is death, marriage, or change of status. And to this extent, I endorse the submissions advanced by learned senior counsel for the chairperson on the issue of change of status.
Sorry.
I would just like to reiterate, Advocate Mkhwebane is not litigating in the capacity of Section 181 in terms of the Constitution. That was made clear in the address earlier. That refers to the juristic person.
I'm sorry.
No problem. That refers to the juristic person established in terms of Section 5 of the Public Protector Act. She certainly doesn't describe herself in that manner. As Justice Masipa pointed out, Advocate Mkhwebane describes herself in the High Court application simply as, at page 10 of Volume 1, Paragraph 3, I am the applicant. There's no reference to her being triggering the capacity of the Office of the Public Protector. Similarly, the reference in Paragraph 1 of her founding affidavit of being duly appointed in terms of Section 1A2 does not suggest that she's here in the capacity of the Section 9 institution. The nature of the relief claimed by Advocate Mkhwebane makes it clear that the relief sought is in her personal interest. It's specifically tailored to her circumstances, undergoing an inquiry into her fitness of office, and not in the interests of the Office of the Public Protector. It relates to securing witnesses to testify and the delay of those proceedings. So we're simply not dealing with a change of status here as contemplated by Rule 15.1. So for those reasons, it was not open, if this court were to find that Rule 15.1 can be utilized as a mechanism despite it not being catered for in the SCA rules, it was not open for her to utilize the notice requirements simply because there hasn't been a requisite change of status. Rather, she needed to engage this court's common law power by bringing a substantive application to allow for substitution or amendment of the citation or introduction of herself as a new party to these proceedings. In the substantive application, Justice Punan, you put the question to counsel for the chairperson as to whether mootness would come into consideration. And the court's been clear that when a substantive application for substitution is before it, it would apply similar considerations as to when considering an application for an amendment. And that would include the question of prejudice. And it would also consider whether there would be any injustice to the other side. And we submit patently where the relief sought in the appeal would have no practical effect. It's patently prejudicial to go through an academic exercise of dragging the other side through to an appeal through the substitution. Justices, those are my submissions on the application of Rule 15. Unless you have any questions, I'd like to move on to make brief submissions on the issue of mootness. Justice, we've dealt with the address mootness comprehensively in our heads, and I don't intend to repeat that. I just want to make 2 points in relation to the address we heard this morning. In order to avoid the obvious fact that this appeal will have no practical effect, what we've heard is that the Gajima principle must apply, and there ought to be a remittal for the declaratory relief. In relation to the application of Gajima, I submit it does not apply in the present instance. The Constitutional Court in Buffalo City said, when considering when the Gajima rule would apply, said, it dictates that where the unlawfulness of the impugned decision is clear and not disputed, then the court must declare it unlawful. This is notwithstanding an unreasonable delay in bringing the application for review, for which there is no basis for overlooking. In the present instance, the unlawfulness, if there was any, is neither clear nor is it undisputed. And the Gajima principle applies only to an unreasonable delay and not to other legitimate reasons for refusing to decide the merits. In response to the submission that the declaratory relief ought to have been dealt with, we have also dealt with the application of 172(1)A in our heads of argument. But I'd like to just reiterate 3 points, if I may. The first is the argument on behalf of Advocate Mkhwebane misconstrues the rule of Section 172(1)A. That section does not determine when a court is required to consider the merits of an argument before it. If this was the case, then it would render the rules on standing, ripeness, and moot nugatory, despite there being legitimate reasons why a court can refuse to entertain the merits of a challenge to law or conduct. The Constitutional Court, in the matter of JT Publishing, Pty Ltd and another versus Minister of Safety and Security, the citation is 1997, Volume 3, SA 514. The court said this: the reversal of the decision reached in the court below brings duly before us a claim for a declaratory order which the applicants wished us to grant on the constitutional issues presented by them. That does not necessarily mean, however, that we are now bound to resolve those issues. Whether we should say anything at all about them must be settled first. Whether we should say anything, I interposed the inquiry because a declaratory order is a discretionary remedy, in the sense that the claim lodged by an interested party for such an order does not itself oblige a court handling the matter to respond to the question which it poses, even when that looks like it's been capable of a ready answer. It goes on to say, it's a well-established and uniformly observed policy which directs them not to exercise it in favor of deciding points that are merely abstract, academic, or hypothetical. And that's precisely the circumstances we find ourselves in the current appeal. And the final point I'd like to make in relation to the declaratory relief is that applying it would then effectively allow for circumvention of the in medias res rule. What it means, it suggests that a court can never declare to grant a declaratory relief, in effect allowing it to grant the same relief a review court would, declaring conduct unlawful. Apart from those submissions, I endorse the submissions from Learned Senior Counsel for the Chairperson regarding the conceptualization of the praise in the notice of motion and whether they support the declaratory relief sought in the submissions today. Justices, the final issue is just the cross-appeal. I don't know, we've set out our basis for that. There's only one additional point that I'd like to make in relation to that, and that would be the cross-appeal is unaffected by the subsequent events. Advocate Mkhwebane was the public protector when the High Court decided the application. The order that she pay personal costs would attach to her and not the current public protector. But if the court has concerns to the fact that any substitution would potentially have an interpretation that the current public protector would face a personal cost order, I submit the court's hands are not tied. Section 19D of the Superior Courts Act grants this appeal court wide powers to confirm amend or set aside a decision which is subject of an appeal, and render any decision which the circumstances may require.
Can that order be the subject of an appeal at the instance of your clients?
Justice Pinnan, we requested the personal costs in the heads of argument on the advancement that the public should not be mulcted with those.
Well, I understand the rationale, I understand what the motivation was, but I'm dealing with it at a slightly more technical level, and that is, ordinarily litigants can appeal against orders that operate as against them.
Yes.
Now, this is not an order that operates as against you. I can understand if the current incumbent, the present public protector, were to have sought leave to appeal, and if she were before us saying, this had absolutely nothing to do with the legitimate business of the office of the public protector, and therefore that office shouldn't have been mounted, because I can understand an appeal at that level. What I don't understand is why would your client have an appeal against an order that doesn't operate against it? You may be aggrieved by the order, but does it give you a right of appeal?
Just put in, that's been pursued in the public interest. I appreciate the concern, the conceptual concern that you have, and I don't think I can take it any further than that.
No, I appreciate that as well. Yes, thank you.
Unless there's any questions from the court, those are my submissions.
Thank you very much.
Thank you. So, I don't know. Yeah. Well, let me start while it's still fresh with the last submission which was made. A lot of astounding submissions have been made, which one doesn't even know where to start. You can't conflate, as my learned friend who just spoke now, the declarator that is sought in terms of Section 8.1d of PAJA, which is indeed discretionary, with the a declarator that is sought in terms of Section 172.1a, which is compulsory. How the two things can be treated as the same beats me. It would mean that the drafters of the Constitution didn't know what they were doing when they put the word must in Section 172.1a and put the word may in Section 8.1d and even in Section 38 of the Constitution. Section 38 of the Constitution and 8.1d are discretionary remedies, but the remedy in Section 172.1a is not a discretionary remedy. That's why I was saying they're two worlds apart. But that's not the only misconception. So the principle of in medias res obviously applies in the respect of the relief sought in terms of Section 8.1d. It even applies, I'm prepared to concede, to the relief sought in terms of Section 38. But it cannot apply without applying the Gijima principle to the relief sought in terms of Section 172.1a. I don't know which part of that is not clear, that these are three separate causes of action. Now, it's very clear that JT Publishing, we all know JT Publishing, does not take into account the subsequent jurisprudence of the Constitutional Court in Gijima, in Asla, there's another case called Notyawela or something like that. Sorry. I think it's the most recent case on this law. Notyawa. Sorry. Just give you the, sorry. Yes, it's Notyawa versus Makana municipality. That's probably the citation that says 2024 of 41 of 4I ILJ 1069, decision of the Constitutional Court. So there's a string of cases from the Constitutional Court that have now applied the Gijima principle. And as I indicated, even the dissenting judgment in Asla confirmed that principle. So how anyone can use the pre-Gijima jurisprudence to make the point that the relief in 172 is all discretionary, both A and B, is just more than astounding. Now, we are told that something else which is, don't know how to describe this one. My learned friend says that the principle in Gijima only applies to unreasonable delay. That is just false. This is what the court said. It didn't confine it to unreasonable delay, but to all procedural hurdles, as I think that was the word that was used, and procedural obstacles was another word that was used. You'll find that in Asla, paragraph 67. It says, on the one hand, there is a long line of cases explaining that the state must adhere to the procedural requirements of review. We all know that, whether the ripeness, mootness, in medias res, and so on, not just on delay. And then it says, including timeous approaches to the courts. So it's not confined to timeous approach, including that, right? Then here's the real law. On the other hand, Gijima implies that these procedural hurdles, all of them, not just unreasonable delay, while important, can sometimes yield to the injunction under Section 172(1)A to declare invalid that which is inconsistent with the Constitution. So how can anyone stand here and say that judgment is confined to unreasonable delay? Well, it says it includes unreasonable delay and all other procedural hurdles. And then at paragraph 68, this is not even something that's introduced by Gijima. It was introduced in Kumalo, which was in 2014, I think. So at paragraph 68 of Asla, it says, in Kumalo, this court cautioned against allowing procedural obstacles, not just unreasonable delay, all procedural obstacles, from preventing, which is what is being asked of you today, from preventing a court from looking into a challenge to the lawfulness of an exercise of public power. Square J stated, quote, a court should be slow to allow procedural obstacles, all of them, to prevent it from looking into a challenge to the lawfulness of an exercise of public power. Can't be clearer than that. But that's paragraph 68. So it's false to say that the Gijima principle only applies to unreasonable delay. It's just patently false. Then we are told that, I have to say this. As I said earlier, the reason why we're here before justices, people called justices, is because this is where justice is to be obtained. And we had, as I say, we did not get justice in the Western Cape Court because of the complete misapplication of the in medias res principle, which only applies to reviews.
Sorry, I don't want to interrupt you, but doesn't
Yes.
Minister 1 make it applicable to declaratory relief as well?
Doesn't?
Doesn't Minister 1 make it applicable?
No. Okay, let me explain. No, Glenister 1 doesn't at all do that. Glenister 1 talks about legislative, legislative power of the National Assembly. In other words, what it says is that until the legislative process is, in other words, when it's a bill, to put it simplistically, you can't challenge a bill. That's what it says. Because we all know why you can't challenge a bill. Because it's not an act. It's not. That's all that Glenister. It's got nothing to do with what we're discussing here. Glenister is about that. So and in any event, Glenister is also an earlier decision. I'm saying
It's been overtaken by
in that line of cases. So Glenister, JT Publishing, what have you? All those cases predate the Gijima principle. Asla is the court case you must look at, which is where that case, well, we must look at Gijima itself, obviously, but Asla is where it was applied and explained in the terms that I've just explained now. Paragraphs 61, 66, 67, 68. All right. So okay. This is the point I was making, that because of the misapplication of a technicality called in medias res, which I said I'm prepared to concede for the purposes of today. Let's assume that court was correct about in medias res, but that cannot entitle it not to address the real violation of Constitution, justice. That's why we always talk about the interest of justice. Justice. That's what we wanted there. We didn't get it. That's what we want here. And the reason we didn't get the justice there was because of that technicality. Now here it is, I don't even know what to call it. But there's a whole argument that we must not get justice here as well of that injustice. Why? Because of a technicality called substitution, which is now being opposed all of a sudden in this court. My learned friend, Mr. Jamie, addresses a matter which he has not opposed and is allowed to go on about the issue of substitution, which they had the right to oppose when we filed, and they elected not to. But now suddenly it's the big reason why we must be denied justice. Well, let me address it. The new technicality over the technicality of the Western Cape that is being raised here is completely has no place in these proceedings. There's Maposa, there's TechMed, there's a series of cases where Rule 15 was applied. Nobody has said why that rule was applied in those cases by this court, but in this case, suddenly it must not be applied. Right? And then the presiding judge this morning gives us a 2-page document to say on this Rule 15 issue. But that 2-page document, the only thing it does is to prove that Rule 15 applies here. Because if, what paragraph 25 of this Celia's judgment, no, I told you that in chambers. We both told you.
I don't know whether that's the way in which you put it is to suggest that that's a criticism of me and my counsel.
No.
I was being of assistance to counsel and drawing to their attention an authority that they perhaps may not have been aware of as a result of their own researches. So and when I gave you this 2-page document, I said, I asked my secretary to assist, and it's not the full judgment, but I drew your attention to what I thought was the relevant paragraph of the judgment.
Yeah, for which we are grateful. I'm sure we said, if we didn't say it in chambers, we'll say it again. Thank you for that.
Yes.
And also, if we didn't say it in chambers, maybe we say it now in public. We were both not aware of we said it in chambers, but it might be important to repeat it here, okay? So I don't know where the criticism is. It's a compliment. I'm saying unless if the authority was being given to not to assist us. Because I'm saying I'm glad for the assistance. Thank you very much. Because it assists us in proving the point we're making, that paragraph 25, you would not have this, what is said here by, I don't know who the church was, but it said that as recorded above, notice of substitution in epistle capacity as the second appellant by the executives of her deceased estate was given in terms of Rule 15. And then it says, in so doing, Rule 15.2 was overlooked. That's all I'm saying. So that means Rule 15 applies to this court. That's all. And it says, if Rule 15 applies to this court, as this judgment, which you, thank you very much, gave to us, makes it very clear, then Rule 15 applies. So it's another, in the long line of Maposa, TechMed, and now we have armed with, thanks to Justice Bonan, with the Cilliers case, to make that simple point, that Rule 15 applies here. Because if Rule 15 didn't apply here... Yes?
What it says is, it says, the first provides of the Rule 15.2 was only,
Yes.
which states that save in the leave of court, granted on such terms as to it may seem meet, no such notice shall be given after the commencement of the hearing of any closed matter.
Yes.
And then the judgment says that this is the important bit. The leave of the court of law, or the leave of this court was not sought prior to the filing of this notice in terms of Rule 15.
Exactly.
And then it says, absent an application to court for the substitution of the executors, the purported substitution is irregular.
Yes, exactly.
So you agree with all of this?
I agree 1,000%. But this shows exactly that A, Rule 15 applies. It shows B, that you cannot do it without a notice asking for the leave, which we did. And C, it shows that exactly, and it says in that court or this court, which means it applies. This court means the SCA. That means it applies here. Okay? Then thirdly, why would that judge say the proviso has been overlooked? You don't get to the proviso if Rule 15 doesn't apply. So this proves beyond any doubt.
So if we follow that decision, you'd be comfortable with it?
No, Judge Justice. You know, this is a serious matter where what we are saying is that if you follow the point I'm making, which is that this judgment proves that Rule 15 applies here, that's all. You must follow that.
It doesn't just apply in part, it applies in its entirety. Now, do you accept that this is a precedent that we are bound by?
Yes, as you are bound.
Are you suggesting that there is any basis to distinguish this authority on the facts of the present case?
But how could I do that? How could I say something is supporting me and want to distinguish it? What is that? How could I do that? I can't. If I'm bringing authority here, I say Asta or Kijima, and then I must also distinguish it and rely on it at the same time. No. I'm simply making the point, and I'm going to make it, that this judgment adds to the fact that the Rule 15 applies here. There's no debate about that. It's true that it then says, in that particular case, whatever, Rule 15.2 was overlooked. But I'm saying even that statement proves that Rule 15 applies, because you wouldn't apply the proviso if the rule itself didn't apply. Okay. So, and then the court, this is where the distinguishing factor is. It says there was no application before this court. In this case, there is a Rule 15 notice. Okay? So that's the issue. The second issue, which also makes it clear that Rule 15 applies, and is not discretionary, as was postulated, is the wording of Rule 15.1. Right? Rule 15.1 is couched in peremptory terms.
We're not spoken about the discretion. We're spoken about the discretion in relation to situations where one doesn't merely file a notice in terms of Rule 15, but one is required as a litigant to file a substantive application for substitution.
Yes.
And in relation to that application, a court exercises a discretion in weighing out the potential prejudice to the respective.
Yes, but
that's
what?
The discretion that is offered.
Yes. Okay. Well, but we're not there. My learned friend, Mr. Jamie, said the only issue that we are at idem about is that we are not there. That Rule 15 was intended to avoid that application that you're talking about. The notice, in fact, that's what I was saying earlier in the morning. For the purposes of Rule 15, the notice is the application. It is the simplified version, because the drafters of this thought they should intervene in favor of those who want to. So that situation does not arise at all. So here we are in the world of Rule 15.1, which has no discretion. It says, no proceedings shall terminate solely by reason of the death, marriage, or other change of status of any party thereto, unless the cause of such proceedings is thereby extinguished. Very simple. Peremptory provision, no discretion. No proceedings shall terminate, which is what is being sought here because of that. So if we are going to, we can, it may have said no proceedings may, then there would be a discretion. So it's completely peremptory. Of course, in that other situation, which has nothing to do with this, where there would have been an application, it may or may not, I don't know whether there's a discretion in that situation. But in this situation that is before you, there's no discretion. It's a peremptory provision of Rule 15. Right. So what do we have? We have a peremptory provision, which you must apply, and we have a long line of cases, including the one we were given this morning, that prove that the rule applies here, contrary to what my learned friend was saying for both of them. My learned friend, Mr. Jamie, backtracked. At first he said it does apply, obviously, but when he thought there's an opportunity to backtrack, then he says, no, it doesn't. Rule 15 only applies in the High Court. That's not true. Because it says any proceedings, that includes these proceedings. The confusion is really simple. It is this thing about the commencement. The commencement does not mean, really. What Mr. Jamie is saying is, so Mr. Jamie is saying we should have brought the substitution application in the High Court. How can that be? So it means if you are doing it as a result of death, you must bring it before you die. So how could you have brought it in the court in March 2023 when there was the change of status had not occurred? But that's the kind of submission that is made here, that the application should have been brought before the change of status occurred. You are taken to the page 50 of the core bundle, and my learned friend says that we said the application is granted and paid with costs, including the costs of 3 counsel. Of course, that was what he forgets is to look at the date at the bottom. 27th June 2023. All right? There was no change of status that had occurred there. So she was indeed the public protector on that date. So how could she have said there when she was filing the notice of appeal, by the way, I'm changing my status as a clairvoyant because my status might change as a prophet. Now, that submission is just devoid of any substance, to be honest about it. And that is why we say the application is granted with costs including the cost of tree counsel. Because we are saying, yes, Mr. Jamie is right. We are saying at that stage, give us all the relief. But that doesn't stop us from coming here now and saying, although we put that we wanted all the 5 prayers in June 2023, we no longer can ask for prayer 4 now because of the reasons that we've discussed. Since when is that a crime? And Mr. Jamie, also, and I'm quite astounded by this because I know him to be better than this. But he reads the prayers and stops at prayer 4. He says that there's no distinction between the relief and the... But the only prayer he doesn't read is prayer 5, because that's the prayer that's completely against him. We don't do that. Because the prayer that he didn't read says, granting any further just equitable remedies in terms of Section 8 of PAJA, Section 38, we've discussed that, and or Section 172(1)(b). So that's the gist of this whole thing about the alternative causes of action. So you can't read all the prayers that don't relate to the alternative cause of action and leave out the one that does, because that's misleading the court, to be honest. So if there's an answer to prayer 5, then you must read prayer 5 and answer it. You can't just not read it. Okay. Then he says that I don't want to misquote him. Sorry. Yes. The founding affidavit, this entire application is based on the review, and the founding affidavit makes that clear, quote unquote. That is false. Let's go to paragraph 72.3 at page 29. Where we outline what we say the issues. It's paragraph 72. We say these are the questions that arise. One of them, forget the other ones, PAJA and what. Ought this honorable court, therefore, I'm reading at 72.3, declare their decision of those people to be invalid, unlawful, and or unconstitutional. And then, in case somebody doesn't know what we're talking about, we put in brackets, in terms of Section 81D, that would be PAJA, of PAJA, Section 38, and or Section 172(1)(a) of the Constitution. And we are told here that there is nowhere where we distinguish between those 3 things. 81D, which is PAJA, Section 38, which is the Declaration of Rights, and 172(1)(a), which is the Declaration of Invalidity. How can that be said when the papers are here speaking for themselves? Then, in case this is not clear. You go to, I think it's volume 9, page 1633. This is now elementary pleadings to show that this is an alternative that's being asked for. Page 1633, that's in our replying affidavit, paragraph 176. Advocate Mkhwebane says, I reiterate that I have made out a case to demonstrate that my fundamental rights have been breached and must, underline the word must, be vindicated by means of a declaratory order. And here's the important part. Irrespective of the review grounds or cause of action. In other words, irrespective of the review cause of action, which I may lose, I am saying my fundamental rights have been breached and must be vindicated by a declaratory order. And somebody stands up here and says, these affidavits do not make it clear that there is a clear separation of an alternative cause of action pleaded in terms of 172.1a. When that section is mentioned by name, we can't do that. We can't. At least it should not be allowed. And there are many other places. I don't want to you could go to page 16, paragraph 29, page 420, paragraph 229, page 69. You'll find I'll just do one for the sake of saving time. Page 69 at 229 paragraph. We say, violations of fundamental rights, big heading, section 10 and 34. In this section, we deal separately with the alleged violations of my fundamental rights as enshrined in the Bill of Rights, with specific emphasis on my rights of dignity in terms of section 10 and access to justice in terms of section 34. These are self-standing grounds for the declaratory and appropriate relief sought specifically in terms of section 38 of the Constitution. In other words, even if it were to be found that the Paja grounds or principle of legality was unsuccessful, this Honourable Court will still be called upon to grant the relief sought to any other appropriate, just and equitable relief, that's 172.1b, in terms of section 38, alternatively in terms of 172.1b thereof. I mean, as I say, there are hundreds of other examples, but for somebody to stand here and say these affidavits do not say that do not make it clear that we are dealing with a completely different animal is just unfortunate, I think, to put it mildly. Now, it's very clear from paragraph 5 of the notice of motion, it's very clear from the passages that I've read that there's an alternative cause of action which was ignored. Then there's this thing about the attorneys. This is a complete misunderstanding of what has happened here. This is what has happened. The other side, as they are entitled to do, invoke Rule 5. I'll paraphrase what that means. What that means is that the rule is very clear. It says, just to paraphrase, if the other side disputes the authority of your attorney, then you must put a power of attorney. Fair enough. Same as Rule 7 of the Uniform Rules. Now, what do? They say, you've launched an appeal under the name of the public protector. And we want you to show us that the public protector has authorized attorneys to act on your behalf in that. Fair enough. We then come back and say, oh, you are right, dear opponents. We don't act for the public protector, and but we do act for Advocate Mkhwebane, right? And how do we show that we act for Advocate Mkhwebane? Here is a notice in terms of Rule 15 for the substitution of the public protector that you want to protect the public purse and what have you. Here's a notice so that now she's standing up on her own 2 feet to say, I'm now here as myself. If there are any costs, there'll be costs against me. So the public purse is saved, thank God. Right? Now, if the opponents wanted to invoke Rule 5, then they should issue, once that has happened, because there's now a substitute, that party in respect of which the Rule 5 was being invoked has disappeared out of the scene. All right? And if they wanted to question the authority of Ms. Mkhwebane now as herself, they should issue another Rule 5 and say, Ramushu, Twala. No, that's exactly what the rule says. Let's go together. Yes, no, let's go to it together. Where's the volume 1? Sorry, Justice Bernard. Oh, I'm sorry. Yeah, let's read it together. It's Supreme Court of Appeal, Rule 5. Right. Rule 5.1, let's start there. Okay? It says, as is the equivalent of Rule 7, a power of attorney need not be filed. Right? That's the operational thing of them. But, so the statement is that a power of attorney need not be filed. Right. But the authority of a legal practitioner to act on behalf of any party, and any party in this case, let's say, is Advocate Mkhwebane, within I've just accepted that. I've said that when they did the first Rule 5, no. Well, you stopped me midway, so let's deal with it, with the issue that you've raised.
Who was that attorney acting for at that?
At that time is what I've already said 5 minutes ago. They were entitled, perfectly entitled, to protect the public purse by asking for that attorney. I've said that twice now, that they were perfectly entitled to do so, and to question the attorney in defense of the public purse. But I'm saying, once it was then clarified to them that she's no longer acting for the so-called public purse, she's now acting for she now has attorneys who are acting for her as a human being, like you and I and everyone else. Then this is what happens. It says, after it has come to notice to any other party so acting, that's them, or with the leave of the court on good cause shown at any time before judgment, be disputed. In other words, if they now wanted to dispute Ms. Advocate Mkhwebane's the power of her attorney to act for her.
This is a dispute that pertains to the authority of the attorney.
Yes.
It has nothing to do with her.
No.
Let's read the rest of the rule.
No. When it says the attorney of any party, the party means her. Okay? So
and whose authority is being disputed?
of her attorney now.
There wasn't that time.
No. I'll do it slowly again. At that time, when the first Rule 5 notice was issued, it was perfectly great, legitimate, in protection of our tax. All right? That then happened. Then what then she did was to indicate, to say, I am not acting as the public protector. So you don't need the authority of Ms. Galeka, I think is the public protector now, for that. Because if she was insisting and say, forget it, I don't care what you say, I might have been impeached or not impeached, but because I was the public protector when the calamity happened, I'm still, if she was taking that position, then you would have to either get a letter from Ms. Galeka authorizing her to do so, or the power of attorney. But she's not saying that. She's saying, I relinquish that status. I'm throwing it away. And I'm now coming to this court as any other citizen. Now, they were entitled to say, well, even as that citizen, we want to invoke Rule 5 because we don't believe that your attorney has a power. And then that attorney would have included the or did the power of attorney. Anyway, that's really what the rules say. So, okay.
Unless a power of attorney is lodged with the registrar within that period.
Yes.
That's the rule operates. Absent a power of attorney on behalf of the party who is properly before the court, it operates to disqualify the attorney from acting.
Who is the party? The party is the public protector.
At that stage, who was the party?
It was the public protector. Is that party here now? No. So how could?
So that's precisely the point.
Yes, but honestly, this thing is very, very simple. It says that if in other words, two things can happen, Justice Bonner. If you invoke Rule 5, the other side can say, "Oh, you got us now," and that is the end of the matter. Or it can say, "Here is the power of attorney." That should be patently obvious. So those are the two things that can happen. So if this other party was just a fly-by-night chance taker, that will be the end. We'll never hear from them again after the Rule 5 notice has been invoked. But if it is not a fly-by-night party, it will then file a Rule 5 power of attorney. This party before you does not say any of those two things. Firstly, it's not saying, no, I insist. It says, throws in the towel, so to speak, and says the authority of the public protector is non-existent. So I can't give you something that I don't have. And for that reason, the party called the public protector gets out of the window because of the failure to give the power of attorney. That could have been the end of the matter, but it was not. Ms. Mkhwebane files a Rule 15 to say, I accept that the public protector is gone, but I want to be substituted, all right? Substituted as myself into that position. Anyway, that's...
So are you saying by filing the notice?
Right, this is 15.1.
Yes.
Mm-hmm.
Advocate Mkhwebane was automatically substituted as the appellant in the matter, and there's no need for an application. So the leave of the court was never sought. I'm confused by the document because it says notice of application. So is there an application that this court is was entertaining, or this was a notice to say I'm telling you that I'm now substituting the appellant?
No. There should be no confusion. She was saying, Justice Masipa, that I am conceding, okay, that the public protector, qua public protector, can no longer be the appellant. What I'm doing, and that's why I'm saying at that point she could have made that concession and gone home. But she says, no, I am applying to this court in terms of Rule 15.1 to be substituted. Substituted means to be put in the place of that. It's like in soccer. You substituted to be substituted in the place of that person who has now died or gotten tired or broken an ankle if it was soccer. Okay? And that is, it can be that she takes the attitude that was sufficient. Then what have we been doing here all day? Because what we're doing here all day is to move that application, because that application can only be moved here, which is unopposed, by the way. So if we took the attitude that by simply putting the notice, what's the problem? Then what would you have been doing here all day? All this day we've been moving the unopposed application to substitute Advocate Mkhwebane for the public protector, which I don't understand what the problem is about that.
So if that's the position, then how would they have already filed a second Rule 5 notice?
No, because they would say that you are now saying, let's say it was someone who had died. You are now saying your father or your mother has died, and you, the son, and now must be substituted to be the appellant, right? Now, we have reason to believe that even you, the son, are not a properly authorized. And if they did that, they have to then issue a Rule 5, and then me, the son, I will then give them my attorney's power of attorney. It's that simple. So there's okay. Anyway, or alternatively, they could say, Justice Masipa, no, we are opposing your application, as they would if it was an amendment application. And then we know what would happen. But they don't do any of that. They don't oppose the application stroke notice of 15.1, and they don't contest the authority of the attorneys insofar as they are acting for Justice Mkhwebane, for Advocate Mkhwebane. Finish and clear. Okay. Now, yes, there is. Okay. Now, my learned friend for the DA says that it's not the ASLA Gijima law doesn't apply because the transgressions are not clear-cut and so on. I honestly don't think I need to address that. I can just make this point, which will make it easier, a shortcut, which was presented to me by Justice Mudle. If you go to that rule, paragraph 47, Justice Mudle, that we spoke about, which is the justification really for the entire judgment, and you picked it out correctly. What is wrong with that judgment is that, as I said, it elides actively, if I may put it that strongly, the real complaints of what we're saying were the violations. So, for example, it says we don't know why she's not she's complaining about the temporary absence of her lawyers, because after that a postponement was given. That, even if that were true, that only applies to the closing out of the lawyers on the 13th of September. They don't say anything I mean, I don't know how wrong you can be. More than, they say nothing about the closing down out of the lawyers on the 1st of November, closing down of the lawyers on the 2nd of November, and the leading of a crucial witness in those days in the absence of lawyers. So how anybody can come here and say that the violations are not, don't speak for themselves. Secondly, then there is the Dube situation. I don't want to go through that again. There is a situation where one of the pair of the people is married to the initiator. The only thing you get, they say, no, she's not a complainant.
Haven't you covered all of this in your earlier address?
No, I haven't. I'm saying that the people were allowed to stand here and say that the violations are not as I'm describing them, and therefore the Gijima principle doesn't apply. So I have a duty to my client to reply to that.
Fair enough, but not to cover argument that you had addressed in your main address. In
No,
other words,
that's exactly what I'm not.
if you just focus on a reply to what was raised, the submissions that were raised, without necessarily repeating what you had said earlier.
Well, I can't do that. I'm unable to do that. I don't know how to reply without replying, without saying why it's wrong what they said. Yes. Maybe I don't understand the request. The only way I can reply to what they were saying is to demonstrate that they are wrong, and I was busy doing that. All right. Now, I was saying and I did this deliberately, as I said. I could have stood here and give you the 17 violations. I think 14 for the chairperson and 3 for Mr. Mileham. But I decided that it would not be necessary to do that. I'll use one of each. And all I'm saying is that even if you take it at that level of the one of each, the closing out of the lawyers and the patent conflict of interest, no one should be allowed to stand here and say that the violations in a constitutional state don't speak for themselves. I mean, what must happen? People must be shot between the eyes for it to be a violation of the Constitution. That's all she's saying. Ms. Mkhwebane is simply saying my rights were violated at that point, as Justice Krichla put it, at the source of the violation. That's how he puts it in the Forze case. Now, if we accept that submission was completely wrong and not supported by anything in front of you, then we are in the heartland of the Gijima principle. That's really the only point I'm making. That if we accept that, because that's what Gijima says, it says if the violations are as patent and glaring and clear-cut as in this case, then you can't deny the applicant of their rights. And I want to go further to say you can't do it on a technicality, whether that technicality is mootness, whether it's ripeness, whether it's delay, whether it's substitution for that matter. You can't, that's the gist of what the Gijima principle is. Then, finally, my learned friend doesn't, again, says something that's startling. Section 15.1 is there to invoke the 173 powers of this court, right? The inherent jurisdiction, and I think to his credit, Mr. Jamie acknowledges that. But in the same breath, he says that doesn't apply to this court. How can that be? Section 173 states that it applies to this court, of the Constitution at least. Sorry. Yeah. Just in case there's any debate, it says 173, the Constitutional Court, the Supreme Court of Appeal, that's here, and the High Court of South Africa, each has the inherent jurisdiction to protect and regulate their own process and to develop the common law taking into account the interests of justice. So, to the extent that the powers in 15.1, which Erasmus says, are a mere codification, if you like, of the Section 173 powers, of the inherent powers, and the simplification, because Erasmus says that that rule does two things. It asserts the inherent power and it simplifies the process. To that extent, then surely it must apply to the High Court, the Supreme Court of Appeal, and the Constitutional Court. That's so you can't again stand here and say that Rule 15.1 doesn't apply. Yes, it is part of inherent jurisdiction, but it only applies to the High Court. Where does that come from? Because the inherent jurisdiction now is no longer encapsulated in the common law. It's encapsulated in Section 173, which mentions this court by name. Yes. And it all really comes down to one final submission, which is this, that when the Constitutional Court says that this court, or any court for that matter, can overlook all these technicalities, whenever it is called upon to perform its most glorious duty, which is to vindicate the Constitution and to assert the rights, human rights of persons who come here. That cannot be something that court said lightly. It can't be. Because as lawyers, when you read it, it almost offends your sense. How can you be allowed to get away with undue delay, mootness, ripeness, and all these things? But that court made that statement with its eyes wide open, so that men and women who want to assert their constitutional rights and use the Constitution as their shield instead of self-help or violence or all sorts of things, their path to doing so must be opened up as wide as humanly possible. And that's why that came from the Constitutional Court now, recently, but it came from the drafters of our Constitution in 1996, by the sheer expedient of using the word must. That's what they wanted to achieve. And to the extent that there was any doubt, that doubt has now been removed in Gijima, in Asla, in Notyawela, and a long line of cases. So that justice must be done, and a person must be allowed to vindicate their constitutional rights. Not a myriad of technicalities thrown left, right, and center and upside down, in medias res, mootness, substitution, this and that. That's exactly what that line of cases say should not be done, justices. Sorry, just one thing about the cost thing. I don't have to address that because I think Justice Ponan has addressed it correctly, except to just make the point that you can't have a circuitous argument that says don't substitute but mulct with costs. Secondly, it goes again to Justice Masipa's question. The concession, quote unquote, or the throwing of the towel to say this is not the public protector that is here, ipso facto means that Advocate Mkhwebane, as the substituted party, the cost must be against her personally anyway, because she's the only person who is before you. So there's no question about the so-called cross appeal. There's no one else who can bear